All right. Good afternoon, everybody. We're about to get started. My name is Arvo Mikkonen. I'm the president of the Oklahoma Indian Bar Association. Just some logistic things at the outset. If for some reason the Zoom comes down, we will send out another link via email to the email that you provided if we have some kind of technical problem or technical difficulties. So if that happens, we'll send out another link. We hope that won't happen. It's never happened before, but in case it does, that's what we'll do. The agenda was displayed for a short time earlier. We're going to start, basically, we're going to have a full session from 1 to 5 o'clock. If you need to take a break, you're more than welcome to do that, but we're going to pretty much stick to the schedule. We may take a short time during the question period, which is going to be 10 minutes after, right before the top of the hour. So that'll be from 1:50 to 2 o'clock for the first session, and then 2:50 to 3, 3:50 to 4, 4:50 to 5. So if you need to take a little break in there, we'll do that. We just want to make sure that we get the full amount of credit for everybody for their CLE. We are in the process of applying to the Oklahoma Bar Association to get the CLE credit for you. It's not yet been approved, but I'm sure that it will be. We've done this multiple times. The materials are all contained on the Dropbox. There may be some additional materials that will be uploaded, and if that's the case, we will let you know about that. You should have gotten the Dropbox link in the email that was sent to you. If you need it, let me know and I will put it in the chat box. At the conclusion of the seminar, we will ask you to do one thing to get your CLE credits, and that is to send an email with your name, your bar association number, and the 4 words that we're going to give. We're going to give a word for at the conclusion of each of these hour sessions. And you need to include all 4 words, your name, and your bar association number. Please make sure to include your bar association number. We've done this before and people have forgotten to put it in. So please don't neglect to do that. There is an evaluation form that's in the Dropbox. You can use that, or because we're required by the CLE to give an opportunity to provide feedback, we would welcome any comments, anything that you might say about what you thought about today's CLE, and when you or when you send in your email for your CLE credit with those code words. I want to thank the participants today, and we're going to get started momentarily. I also want to thank Joseph Williams, one of our officers for the Oklahoma Indian Bar Association, who has coordinated and set up the Dropbox and has been helping, and hopefully we'll be able to monitor any questions that we might have in the chat room. Also, we decided today to do this rather than doing it in a seminar format. We decided to do it in a meeting format so that those of you that may want to ask a question at the conclusion of the session, we can see who you are, and I think that just promotes a little bit more interaction as opposed to just responding to messages from the chat. Certainly, if you have a question or a comment and you want to provide some information in the chat room, you're more than welcome to do that. I think those are all the logistic issues. If for some other reason you need to contact me, my cell phone is 405-420-9912. I'll put that in the chat room, or 405-640-8850. That would be the best way to communicate with me by chat. Okay, I see our presenters are pretty much ready to go, I think. They're going to be running their PowerPoints or any written materials they have from their own computers. If we have an issue with that, then presenters let me know, and I'll try to share that document on the screen from the base computer here. All right, so I think we have our first presenter. Also, we're going to ask you to keep your audio muted unless you want to ask a question, and we're going to leave that to the end. just so that we don't get any background noise. This is being recorded, and we may be able to provide it for others who were not able to join us today at a later time. So I want to introduce Professor Taiwagi Helton. He joined the faculty of the University of Oklahoma College of Law in 2001. He teaches environmental law, property law, and Indian law. And his research emphasizes environmental and natural resources issues relating to Native Americans and nation building in Indian country. He started out his legal career as a law clerk for the Honorable Robert Henry, 10th Circuit Court of Appeals judge. He's served as a special justice for the Cheyenne-Arapaho Supreme Court. He's on the board of directors for Oklahoma Indian Legal Services. In 2012, he received the OU Regents Award for Superior Teaching, which was the university's highest award for teaching excellence. He graduated from the University of Tulsa in 1999 with a Juris Doctorate degree. He also received a Master of Laws degree from the Yale Law School in 2001. While at Tulsa, he served as the editor-in-chief of the Tulsa Law Journal and earned a membership in the Order of the, and I don't know how to pronounce this, Curule Chair. That sounds a very impressive resume there. So I want to welcome Professor Helton and take it away.
Thank you so much, Arvo. It's an honor to be here speaking to the Oklahoma Indian Bar Association. Because you are my audience, I'll be a little bit more candid in my assessment of the case. Oh, I forgot to say, Arvo, it's Curule Chair. It's sort of like COIF, but it's COIF's competitor, I guess. And it was a long time ago. If we have a computer crash, I'm going to guess it's mine because my IT department told me they've given up and they're just going to buy me a new machine because although this is working now, I can't access my hard drive anymore. And they gave up before or after I did. So hopefully this will work out. My job today is to give you some background, and I'm hoping that I can also put Castro-Huerta in its larger context if the time allows. So I'm going to try now to share my screen. Now that I'm sharing my screen, I don't get to see you all as well, so please interrupt me if there's an issue. If assuredly, if you are on this meeting, you have been paying attention to what's been going on in the relations between Indian tribes, the U.S. Supreme Court, and the state of Oklahoma over the last several years. Just at the outset, you might wonder, how did we go from McGirt, this case just a couple of years ago that celebrated or at least honored the foundational principles that recognize tribal sovereignty, and Castro-Huerta, which seems to flip Indian law on its head in a troubling way. And I'm sorry to say that the explanation is not very satisfactory for those of us who are students of the court or followers of Indian law. And that's because if you look at the McGirt case, which was a 5-4 decision in favor of tribal sovereignty and the non-disestablishment of the reservation at issue there, and compare it to Castro-Huerta, which is a 5-4 split favoring state jurisdiction in Indian country in a way that is entirely unprecedented, the only explanation is that Justice Ruth Bader Ginsburg was replaced by Justice Amy Coney Barrett, and that was the one vote that flipped, changing the former dissent into the majority. So Castro-Huerta is an opinion by Justice Kavanaugh that I think is best described by Justice Gorsuch in the dissent, which is that you couldn't come up with a more ahistorical and sort of anti-Indian law decision. I would describe it as the most ahistorical and anti-originalist decision that the court could have conjured up. First, though, before we dive into Castro-Huerta, I wanted to go back and just remind everyone of the foundational principles of Indian law, which are made into American law and described and articulated in 3 cases by Chief Justice John Marshall called the Marshall Trilogy: Johnson versus McIntosh in 1823, Cherokee Nation versus Georgia in 1831, and Worcester versus Georgia in 1832. These cases give us notions of discovery and conquest, which are merged together in Johnson versus McIntosh by Chief Justice Marshall and made part of American law. And then in Cherokee Nation versus Georgia and Worcester versus Georgia, we are given the idea of domestic dependent nations, and then that idea is fleshed out a little bit. So in Johnson versus McIntosh, land had been purchased in violation of the Proclamation of 1763 in 1773 and 1775 from the Illinois and Piankashaw Indian tribes. Later on in time, the U.S. acquired those lands and transferred those lands by patent to someone else. The Supreme Court, with no tribal advocate in this case, concluded that as a result of discovery and conquest, the United States claim of sole sovereign title or absolute title that was subject to the Indians' right of occupancy meant that the United States did not have to recognize those pre-US transfers. Effectively, to avoid this, the challenge before him, or to get to his result, Marshall created a new form of property that he called Aboriginal title or Indian title, that later gets described as sacred as the fee simple of the whites. But we'll see by 1855 that the U.S. courts don't treat it quite so sacredly. In any event, Johnson versus McIntosh creates the idea of Indian title or Aboriginal title. Cherokee Nation versus Georgia arises because the state of Georgia wanted to remove the Cherokee Nation from land that Georgia claimed, especially after gold was discovered in Cherokee lands. The state of Georgia passed laws not only purporting to claim the land and jurisdiction over it, but nullifying Cherokee laws and claiming that no one could enter the Cherokee lands without the permission of the state of Georgia. Sorry, I just want to make sure one of my co-hosts didn't tell me new news. So Georgia purported to nullify Cherokee laws and claim tribal property. And clearly Marshall doesn't want to hear the case because we are already approaching the nullification crisis. It's quite clear. Things were already tense with the Supreme Court because this unelected branch has already claimed broad federal power in the context of Marbury versus Madison, and federal power or judicial power in Marbury, and then federal power in McCulloch versus Maryland. So to dodge it, Marshall creates a new form of sovereign. He says at the outset, no doubt the Cherokee Nation is a nation. And they've proven that. But the question is, are they a foreign nation for purposes of Article 3 original Supreme Court jurisdiction? And he says that the relationship between American Indians and the United States is unlike that of any other two peoples in the world. That is, he claims that the uniqueness of the American experience means that they are something other than either a domestic state or a foreign nation, and he says instead that they are domestic dependent nations. Now, we should keep in mind, this was a 2-2-2 split, so that two justices said two nations being foreign to each other must be called foreign, and then two said we should do away with all tribal rights effectively, and then there were two on the Marshall opinion that split the middle, and that meant there was a 4-2 decision saying that tribes were domestic dependent nations, and that was neither a foreign state nor a domestic, or a foreign nation nor a domestic state. Therefore, they couldn't invoke jurisdiction. But a year later, he couldn't dodge the question because Elihu Butler and Sam Worcester were two missionaries who entered the Cherokee territory without the state of Georgia's permission. They were then arrested and sentenced to 4 years at hard labor. So now John Marshall has to address the question. He reins in a lot of the broad language from Johnson versus McIntosh, and he says that there are two reasons why the laws of the state of Georgia can have no effect in the Cherokee Nation. He says that the Cherokee Nation is a distinct political territory with defined boundaries in which the laws of the state of Georgia can have no effect. The first reason is inherent tribal sovereignty precludes the state law. And secondly, federal supremacy precludes the state because the United States has recognized tribal sovereignty All three branches have done so, and there are treaties with the tribes. So by the end of the Marshall Trilogy and Marshall's time on the court, we get the foundational principles of federal Indian law. This is the idea that as pre-constitutional sovereigns, tribes remain sovereign, but they are not foreign sovereigns. And there are three parts of the domestic dependent nations doctrine: the reserved rights doctrine, the flip side of which is the diminished tribal sovereignty doctrine; second, congressional plenary power; and third, the trust doctrine. So at the outset, the reserved rights doctrine says that as pre-constitutional sovereigns, tribes have all of the powers that any sovereign would have, except those that they've expressly given up in a treaty or that Congress has unequivocally taken away through its power under discovery and conquest. And then Marshall mentions this third piece, which is, or other powers that have been necessarily diminished as a result of discovery and conquest. He very clearly only has two things in mind: their ability to sell their land to anyone of their choosing. Instead, he says that because the United States claims authority and title, that they can only sell their land to the United States or to someone with the permission of the United States. And then second, in Wooster, he says that if another European power tried to enter into a treaty with them, we would view it as an act of war. This sounds a whole lot like the Monroe Doctrine that was articulated in 1820. So effectively, US claims limit foreign relations and limit their ability to sell their land. But otherwise, tribes have all of the same rights as any other sovereign. So we end up assuming they've got all of the powers. Then we look for evidence that the tribe either gave it up or Congress took it away. Second, congressional plenary power. One of the primary reasons that the Articles of Confederation government failed is that there was an ambiguity in them that gave the power to enter into treaties with Indian tribes to the national government. But there was a proviso that said, but nothing in this article shall limit the legislative authority of states. So a bunch of states just said, our legislative authority includes the power to enter into treaties with Indian tribes to take their land. And that set of claims over the same Western lands that were owned by Indians and competing claims between states contributed substantially to the failure of the Articles of Confederation. So to clear that up, Congress inserted the Commerce Clause in the Constitution that says, Congress shall have the power to regulate commerce with foreign nations among the several states and with the Indian tribes, to make entirely clear that this was a federal power. In other words, they did exactly what King George III did in the Proclamation of 1763, which was to claim centralized national control over affairs with Indians or over Indian affairs. The court goes on to say that because of the Commerce Clause, the branch of the federal government that holds power over Indian affairs is Congress. So it is congressional plenary power. Marshall talked about the relationship between tribes and the federal government looking like a guardian-ward relationship. That analogy becomes part of American law in 1886 in a case called Kagama versus the United States. And in that case, the court said that tribes were once powerful, but had been rendered in a state of dependency, largely due to their course of dealings with the United States. That dependency justifies power over Indians, but the court said that power over Indians can't rest with the states, who, because the local people of the states were often their deadliest enemies. So that power must reside with the federal government. Specifically, it resides in Congress. Now, plenary is just a synonym for full. So what does it mean in this case? Well, it sort of means three things. First, it is a general subject matter as opposed to limited subject matter. Second, it is exclusive of the states. That's one of the fundamental things about that being plenary authority. It is entirely reserved to Congress. It is exclusive of the states. And then also, it is for a time virtually absolute, because after Kagama articulates plenary power the way that it does, in 1903 in Lone Wolf versus Hitchcock, the court says that this power is not subject to the language in a treaty. It says that this power is not subject to consent of the governed. It says that this power is not limited by the trust relationship. In fact, the power arises in part out of the trust relationship. And fourth, he says that because there is a presumption of good faith toward the Indians, the court will presume good faith and won't even look at evidence of bad faith. Effectively, Lone Wolf applies the political question doctrine to the exercise of congressional plenary power, and they don't even look further. Now, we've overruled that part of Lone Wolf. We will now examine congressional uses of plenary power, but we still give incredibly profound deference to acts of Congress. In fact, we continue to hear courts say that only Congress has the power to change the status of Indian lands or change the relationship between the United States and individual tribes. The third component of the domestic dependent nations doctrine is the trust doctrine. And that says that in exercising federal plenary power, the federal government should act in the best interest of its Indian wards. Recognizing that relationships between the United States and Indian tribes are not equal relationships, that over time the United States acquired greater economic and military power, and as a result of that, it was able to force terms of treaties onto the weaker party. The courts developed, anchored in the Marshall Trilogy, rules of interpretation for treaties and statutes relating to Indians. Specifically, these are called the Indian canons of construction, and they're generally described as being 3 rules. We should liberally construe treaties with Indian tribes and statutes relating to Indians in favor of the Indians. Second, we should interpret them as the Indians would have understood them at the time. And third, ambiguities should be interpreted in the Indians' favor. So as a result of this, we should have a very low threshold for recognizing tribal rights or finding that tribal rights have been reserved. And there should be a very high threshold for finding that tribes have lost rights. That is, you need to show that the federal government explicitly took them away or that the tribe unequivocally gave them away. Those are the foundational principles of federal Indian law, and they remain largely undisturbed for 150 years. And I think that we have, in fact, entered a new policy of federal Indian law in which the court is grabbing power not only from tribes and taking away tribal sovereignty, but also grabbing power from Congress. Because again, the court has always said only Congress can take away tribal authority. And you can see from the canons of construction that effectively what the courts are saying is, we won't tell the majoritarian branches that they cannot act like conquistadors. But what we require is that they explicitly tell us that they're acting like conquerors. Having just declared a new standard for governmental legitimacy, that is consent of the governed, it's rather remarkable then for the court not to be protective of that principle, but those unelected justices are deferring largely to the majoritarian branches and saying that if Congress wants to do this, they can. They just need to be really clear that that's what they're doing. Now, those canons of construction end up then protecting tribal rights, but they also have institutional value to the US because they protect Congress from claims against the Treasury, and they protect the court from being complicit in conquest by inferring additional conquest in a case where Congress hasn't explicitly said we're taking this power away. So again, almost undisturbed rules for 150 years. Now, I just came up with a list of these 6 cases that I would throw into the list of the 10 worst Indian law decisions in US history. I say worst because I think they represent a failure of the United States Supreme Court in a particular light or through a particular lens. And I want to distinguish these failures that I think are more excusable from the failures that we see in Castro-Huerta and in one of its predecessors, Oliphant versus Suquamish. So Johnson versus McIntosh. So you'll notice if you look at these 6 cases, in every, Lone Wolf has been described as by at least one federal judge as the Indians' Dred Scott case. Teton was so bad that Congress passed the Alaska Native Claims Settlement Act to compensate for the loss of Aboriginal title after the Supreme Court said Aboriginal title is not a compensable property right under the Fifth Amendment. But if we look at them, Johnson versus McIntosh, the Supreme Court decides that it will not recognize the full property rights of American Indians. Well, in failing to do that, what the court was doing was following the majoritarian branches, because Congress had decided to transfer those lands to other individuals. So the court was faced with this choice of telling Congress what they had done was wrong, or finding in favor of the person who had been there first and in favor of the Indian tribe's property regime. So the court erred in Johnson by failing to be the conscience of the nation and reining in the majoritarian excesses. But you can understand notions of separation of powers and deferring to the majoritarian branches of government help explain Johnson. Cherokee Nation versus Georgia, similarly. First, the Cherokees, when their land was being invaded, went to the president, Andrew Jackson, and asked him to honor his promises to them after they helped him fight at the Battle of New Orleans. He told them that they should go, but that their land in Oklahoma would forever belong to them. As long as the grass grows and the waters flow, it would be theirs as long as they existed as a people. After they left him, they went to Congress, and Congress passed the Indian Removal Act of 1830. So then they went to the Supreme Court. Once again, the court failed to be the conscience of the nation, because what the court did was follow Congress's issuance of the Indian Removal Act, an effectively clear way for removal, at least for that year. They resisted in Cherokee Nation in Worcester versus Georgia, but then famously or apocryphally, President Jackson says John Marshall made his decision, let him enforce it. But in Cherokee Nation versus Georgia, they were following Congress once again, because Congress had passed the Indian Removal Act. Then we jump forward 50 years to United States versus McBratney. Now, this is one of three cases that I lump in with Castro-Huerta, Oliphant versus Suquamish. You'll notice all three of them seem like departures from foundational principles, and all three of them deal with jurisdiction over non-Indians in Indian country. So in McBratney, the court said, in looking at the rules of criminal jurisdiction in Indian country, they looked at the General Crimes Act of 1855, which gives the federal government jurisdiction over interracial crimes and acknowledges tribal jurisdiction over Indian versus Indian crimes. And the court in McBratney concluded that because Colorado's Constitution and Organic Act does not include a reservation of federal jurisdiction over the lands at issue, the court concluded that there was no federal interest in stopping non-Indian on non-Indian crime, only interracial crime. So they narrowly construed the General Crimes Act of 1855, but again, they anchor it in this idea that the United States didn't reserve that right. So they gave a very strained and narrow reading of the treaty or the statute of 1855, the General Crimes Act, in a way that disrupted the rules of criminal jurisdiction and created the first opportunity for state jurisdiction in Indian country over non-Indian versus non-Indian crime. That's the one exception for 150 years, but they anchor that exception in the fact that the federal government didn't reserve its powers when, and therefore the state had those authorities. 5 years later, in United States versus Kagama, here the failing is when they create congressional plenary power. In 1883, an ex parte Crow Dog, their Crow Dog had killed Sinti Gleska, and he was punished in accordance with the law of the tribe. That did not include the death penalty, and that outraged the local Indian agent, and Indian agents had already been pushing for more power and more forced assimilation. As a result, they then went to Congress complaining about ex parte Crow Dog, and Congress passed, that was in 1883, Congress then passes the Major Crimes Act of 1885. That statute gives federal jurisdiction over enumerated major crimes, starts out as basically the 7 common law felonies, then it expands into about 14 or 16 more modern crimes, most of them violent, that gives federal jurisdiction, even if the defendant is Native American. Kagama challenges the application of the Major Crimes Act to him, and in 1886, the court says that although Congress's power to pass the Major Crimes Act is not justified by the treaty power, the spending power, the taxing power, the war power, or the Commerce Clause, they say that because the Indians have been rendered into a state of dependency, power over them must exist somewhere. It's got to exist with the federal government. Here, Congress had passed the Major Crimes Act. The court failed to be the conscience of the nation and failed to protect tribal sovereignty by deferring to Congress, effectively following Congress, and once again, providing a veneer of legitimacy over congressional action. Then in Lone Wolf versus Hitchcock, in that case, the Kiowa, Comanche, and Apache tribes have been promised that their land would not be allotted any further unless 3/4 of the adult males signed an agreement to do so. There was bribery, there was misrepresentation, there was corruption, and still the federal government did not reach 3/4 of the adult male population, but that remaining agreement was then brought to Congress and it was passed as a statute and without the permission of the tribes. There, the court, in reviewing that decision, said once again that as trustee, the federal government has the power to change the asset of the trust from an investment in land into an investment in cash. And the language of the treaty, consent of the governed, and judicial review didn't limit what they could do. In other words, the court was deferring to Congress's decision to break its promise and allot the land without 3/4 of the tribe agreeing. And the court said, we won't tell Congress they can't do that. Leap ahead 50 years to Teton versus the United States. This is another one of those terrible cases. It's written by Justice Reed. Some people have speculated after some justices' papers came out that in a way, Teton might have been a gift to Justice Reed in order to get his vote on the second Brown versus the Board of Education case. But in any event, in Teton, the United States sold off millions of acres worth of timber. The small group of Teton Indians claimed that they needed to be compensated for that loss. And the federal government the Supreme Court once again followed the majoritarian branch, where at the height of the Cold War, we just bought Alaska, and now a small group of Indians are telling us that we can't use the state that we just purchased. And so the Supreme Court follows Congress's decision to liquidate the timber resources without compensation. So when you think of the worst Indian law decisions, almost all of them fall into the category of the court failing to rein in the majoritarian branches, because they've said for a century and a half that only Congress has power in this area. But then we get to Oliphant versus Suquamish, 150 years after the categorical ban on state jurisdiction in Indian country in 1978. Oh, and with the reserved rights doctrine, remember the court saying only Congress can change tribal rights. Remarkably, the court acknowledges that Congress has never taken away from tribes criminal jurisdiction over non-Indians. But Justice Rehnquist couldn't cope with the idea that tribes would exercise jurisdiction in that context over non-Indians. And so he concludes that the reason Congress didn't take this right away is that there was a shared assumption among all 3 branches of government that tribes lack that power in the first place. Now, the court cites none of the treaties in the early US history that actually acknowledge that tribes do have that power, and it relies on incredibly spotty historical evidence, including withdrawn Senate reports and old AG decisions or opinions. But they conclude that the tribe lacked criminal jurisdiction over non-Indians. oddly, they quote the part of Ex parte Crow Dog that says it would be unfair to apply the laws of a different culture to, in that case, Crow Dog. They quote that here as if Oliphant didn't know or couldn't have been expected to know that punching a BIA police officer that was being paid by the federal government and then participating in a high-speed chase was somehow against the law. But in any event, Oliphant is often described as the worst Indian law decision because it flips Indian law on its head. Instead of assuming that tribes reserve the rights unless Congress has taken them away, here the court divests the tribe of power by claiming that it has the authority to conclude that exercising criminal jurisdiction over non-Indians is inconsistent with their dependent status, and therefore the tribes lack that authority. Many people argue that after 8 shifting congressional policy eras, that in 1978, we arguably entered a new policy era of judicial divestiture of both tribal and congressional power, where now the court will claim not only can Congress, but also we can take away these powers from people. So Oliphant versus Suquamish effectively flips the reserved rights doctrine by saying, instead of assuming the right is there, we actually think the right is not there, and then they rely on the absence of some kind of congressional delegation as some evidence that that the tribe didn't have the power. Castro-Huerta does something similar. In 1981, Montana versus the United States extends Oliphant versus Suquamish from the criminal context to the civil context by saying that we think Oliphant stated a general proposition that tribes lack jurisdiction over non-Indians unless one of two exceptions are satisfied. Either the non-Indians have entered into a consensual relationship with the tribe, like leases, contracts, or other arrangements, or the non-member activity on the non-member fee land would have a direct effect on the political integrity, economic security, or health and safety of tribal members. Now, this is striking too, because Montana only applies to non-member conduct on non-member fee land. The issue there, though, is that Indian country was defined in 18 U.S.C. 1151 in 1948 as including all lands within the boundaries of an Indian reservation, notwithstanding the issuance of a patent in fee and including rights of way across that Indian land, 2, dependent Indian communities, and 3, Indian allotments. The court makes no acknowledgement that Congress included non-member fee land in the definition of Indian country. So when we think about the confusion of doctrine over the last 40 years, almost all of it can be put in the lap of the US Supreme Court because they ignored a more recent statutory definition that clearly included non-member fee land within the definition of Indian country for jurisdictional purposes after they had already largely abandoned Oliphant versus Suquamish. So that then brings us to Castro-Huerta. And as I said, Castro-Huerta is really a follow-up to the decision in McGirt. McGirt dealt with criminal jurisdiction, but its first question was, the first question in McGirt was, have the tribal lands been disestablished? If yes, then only restricted fee or trust lands remain Indian country. But if it was not disestablished, merely diminished, then the boundaries of the reservation are legally intact, and all of the area in that within that region is subject to the special rules of Indian country. So first, Indian country is not a term describing property ownership. Indian country is a jurisdictional term that describes a region in which the special rules of federal Indian law apply. In the criminal context, the special rules of Indian country include the General Crimes Act of 1855 and the Major Crimes Act of 1885. And so once the court concluded, using the rule from Solem versus Bartlett, a 1984 case that said, absent strong language of cession and an unequivocal promise to pay a sum certain by Congress to the Indian tribe, then you don't have disestablishment. And so the court said the Muskogee Creek Nation was not disestablished. That meant they had to then address jurisdiction under the Major Crimes Act, and they concluded under the fairly standard and longstanding rule that only the federal government had jurisdiction over interracial crimes, not the state. And as a consequence of that, the state claimed that a parade of horribles would happen, virtually all of which was an exaggeration. The state spent $10 million on a public relations campaign to convince the world that the case was not about tribal governance, but about race and about public safety. It is ironic, I think, or I would just say painful, that this claim of lawlessness in Indian country or in the Indian territory that was used to justify federal courts having jurisdiction in the Indian territory in response to claims about lawlessness therein. The famous hanging judge, Isaac Parker, noted that in his experience, the lawlessness was a product of non-Indians entering the Indian territory and committing crimes, not unlawfulness by tribal members themselves. It was then used to justify statehood. It was used repeatedly over time to take away tribal authority and individual autonomy in favor of either federal or state jurisdiction. And so once again, the state is making this largely false claim that lawlessness is the product of McGirt. And so their argument then is that if they have lost the question of whether the land is Indian country, they then attack that idea that the federal government has exclusive jurisdiction. Remember, it was a big deal for the federal government to interfere with the affairs of Indians themselves. In fact, if you read Wooster, most of the language in Cherokee or in Wooster versus Georgia suggests that even the federal government wouldn't have had the power to interfere with the internal relations of the tribe. And certainly the state lacked that authority. So then in 1855, it is another big deal when the federal government intrudes into Indian country and claims jurisdiction over interracial crimes. But that assertion of federal jurisdiction is silent about state jurisdiction, therefore leaving intact the exclusion of state jurisdiction from Indian country. So, you know, from an originalist perspective, at the time of the founding, at the time of the Marshall Trilogy, at the time of each of the statutes in question, the states were almost entirely excluded from Indian country, certainly in the criminal context. I think one unforgivable aspect of Justice Kavanaugh's opinion is that he makes the assertion that the states by the 1880s, we had abandoned the exclusion of state jurisdiction in Indian country, and he cites no authority for that proposition. The closest you can come to any case that would do that is not the statutes, the Major Crimes Act or the General Crimes Act. The closest you can get to the inclusion of the state would be McBratney. But the problem there is that McBratney is based on Congress's failure to reserve jurisdiction over Indian lands within the state. Oklahoma doesn't have that same situation. Oklahoma's Organic Act and Oklahoma's Constitution does expressly disclaim any jurisdiction over Indian lands. And as a result of that, even relying on McBratney in Oklahoma, or at least in Eastern Oklahoma, is reliance on bad law, or it's applying it in a circumstance where it doesn't apply. So he says that the General Crimes Act doesn't preempt state authority. Well, it didn't need to because clearly in 1855, there was no state authority. Similarly, he says that when you look at Public Law 280, which granted jurisdiction to only 6 states, he says that even though the statute grants some federal jurisdiction to a small number of states, nothing in that statute precludes state jurisdiction. Well, this is astonishing to require that Absent federal exclusion, the state has power because Congress had no idea that it needed to exclude state authority because everybody knew the state lacked jurisdiction and had always lacked jurisdiction. So it's rather amazing that the court would look at a statute that after states asked for jurisdiction in some cases, Congress gave them jurisdiction, then in passing Public Law 280, granted jurisdiction to 6 other states. And looking at those kind of statutes, it's just stunning to suggest that a grant to a very few number of states is not the same, or it somehow fails to achieve blocking all of the other states from having jurisdiction. So it's just stunning that he just disregards these explicit grants because of the absence of state jurisdiction. And he says that that the states had this jurisdiction all along, that they have concurrent jurisdiction with the federal government. It's also anchored in another falsehood. He says that at least by the 1880s, we viewed tribal lands to be within the state. As far as I can tell, the first statements in court, including tribal lands within state land, is for diversity jurisdiction purposes. That is, if somebody lives in the Arizona portion of the Navajo reservation and they want to sue Arizona under diversity jurisdiction, the court said for diversity jurisdiction purposes, we treat the reservation as part of the state. But that then gets extended again without citation by the majority opinion by Justice Kavanaugh, who then says that the states have always had concurrent jurisdiction. This is an astonishing rejection of originalism. It is an astonishing rejection of inherent tribal sovereignty. And I think Castro-Huerta could easily be thought of as Oliphant 2.0, because once again, it flips the presumption on its head. And it now creates the opportunity for the state to claim, not only in the criminal context, but in other contexts, it has concurrent jurisdiction with the federal government. And I think this does shocking damage to the field of Indian law and to doctrine, not only to tribal rights, but also to congressional power. Because when they reallocate rights like this, they're not just shifting jurisdictional rules between tribes in the state, but also between the federal government and the state. And so this is a stunning claim of power over Congress as well as over tribes. We do not ultimately know what meaning this case will have until after we see what other courts do with this case. Maybe it'll be limited to its facts. The dissent makes an effort to limit it to Oklahoma and limit it a couple of other ways. And the Supreme Court and Kavanaugh and the majority simply says, this applies everywhere. Nice try, Neil. One other thing I want to add, Justice Kavanaugh seems to think that he knows a great deal about Indian law. Unfortunately, virtually his only experience with Indian law comes from the Cherokee Freedman cases when he was in Washington, D.C. And that gave him, I think, a very skewed idea of tribes and tribal sovereignty. And you'll notice in oral arguments and in a footnote, Justice Kavanaugh seems compelled to always mention, hey, by the way, did you know some tribes, including the Cherokee, own slaves? And I think that's an effort to take away the moral high ground that tribes often have in cases, because their cases often look like cases involving morality and the illegitimate use of power. And their cases very often look like institutional reform cases because they're undoing a historic injustice. And so taking away their moral authority, I think, is part of his goal. Now, Justice Coney Barrett might be educable on this. She just got here and she chose the Kavanaugh side, favoring more prosecutions rather than fewer prosecutions. She probably thinks there are a couple of other cases where she sided with what looks like tribal interests. And so it's possible that she could be educated on this point, but it does seem as though Justice Kavanaugh might end up taking the mantle of Rehnquist against Thurgood Marshall in the form of Justice Gorsuch, in terms of one of them understanding foundational principles and being largely protective of tribal rights, the other seeming to take a maximalist approach to undermining or minimizing tribal rights. So as I think of Castro-Huerta, again, it could be limited on its facts, but it is such a staggering departure from precedent and from historical policy that it is really hard to predict what will happen to it. I would also note just one last thing, that for 70 years after statehood, Oklahoma claimed there was no tribal governance or Indian land within its boundaries. Then in Harjo versus Kleppe in 1976, an appellate court said tribal courts in Indian territory were not completely destroyed. They continued to exist. And then the state fought, largely in the tax cases, for the next 15 years, fought tooth and nail while it tried to exercise its authority on both trust land and restricted fee land, as well as non-member fee land. And for 15 years, it lost in Sack and Fox versus the Oklahoma Tax Commission, and the Oklahoma Tax Commission versus the Potawatomi, Citizen Band of Potawatomis, and then the Chickasaw, Oklahoma Tax Commission versus Chickasaw case came right after Sack and Fox. But after the court, or this tribe kept, after the state kept losing to tribes, they finally recognized that tribal rights had to be acknowledged. And so they started entering into compacts, coming up with a political solution for taxes on gasoline, tobacco, and automotive registrations, as well as gaming. We saw unparalleled prosperity for tribes and non-Indians in Oklahoma for 15 years. Then we saw victories in the state of New York, in the state of Washington, and the state of Kansas that I think made people in Oklahoma think, or leaders in Oklahoma think, that changing membership on the court now means we've got a chance of winning again. So we've moved into a new era of fighting against tribal sovereignty. And I really hope that we can find a political solution, because I would much rather have the next 15 years be shared built prosperity rather than the expenditure of millions of dollars over the next decade fighting over these kind of rules and just exhausting sort of blood and treasure on these issues. I am 1 minute before my Q&A, so I am happy to stop here and answer any questions that folks might have.
All right, do any of our attendees have any questions? We've got about 10 minutes, so we definitely want to have some interaction here. Anybody have any questions of Professor Helton?
The suspense is killing me.
Well, I'm prepared for this this possibility. One of the issues that I really struggled with in reading Castro-Huerta, and if you go back and look at cases like Warren Trading Post, where there were federal regulation of Indian traders, and McClanahan versus Arizona Tax Commission that basically said in both instances there wasn't any room for state jurisdiction or regulation. And of course, Public Law 280 doesn't just cover criminal law, it also covers civil matters as well. That was the most stunning thing to me in the Castro-Huerta decision, because it seems to me if there's anything that's been more preempted by federal law, it's, you know, who has criminal jurisdiction in Indian country and at what circumstances. You know, you have the Major Crimes Act, the General Crimes Act, the Kansas Act, Public Law 280, Public Law 280 retrocession, you know, the Tribal Law and Order Act, the Duro Fix. I mean, all of those are related to congressional action in the area of criminal jurisdiction. And it's, what are your thoughts about that? It seems like they say, well, it's not preempted, but how can it not be preempted?
Well, first, I think it is preemptive, but secondly, they're looking for proof that Congress preempted a power that the state never had. So it's really ahistorical for the Supreme Court to look at any of those statutes and say, unless they preempt, then the state has jurisdiction, because those statutes were written in the context of there being not only no state jurisdiction, but virtually no federal jurisdiction. So they were extensions of federal jurisdiction into Indian territory in a way that was new and fresh. So we should read those limitations on tribal sovereignty very narrowly as only allowing federal jurisdiction. And in terms of the criminal jurisdiction question, you're right. Since Oliphant, the court has been whittling away on tribal rights, but Congress, which makes both the policy and the law in this area, keeps passing statutes that are supportive of tribal economic development and self-sufficiency, and particularly in the area of criminal justice, providing support and funding for tribal police forces and tribal judiciaries, including, as you referenced, with the Tribal Law and Order Act, and then also with the Violence Against Women Act, increasing tribal criminal jurisdiction over non-Indians. I think one striking thing about the McGirt decision is not only that it reaffirmed the disestablishment rule from Nebraska versus Parker in 2016 and from Solem versus Bartlett in 1984, but it also seemed to suggest that Montana's grant of state authority over non-member fee land was also in question, because he talks about, with these boundaries intact, we presume against state jurisdiction within the reservation boundaries. That seemed to me to suggest that Gorsuch at least might be willing to revisit the very bad case of Montana. Castro-Huerta seems like a reaction to both of those things, but clearly favoring, increasing states' rights and state power in a way that we just haven't seen even the modern court do in a long time.
All right, thank you. This is going to be the first of our 4 code words, so take a note of it. The first code word for the conclusion of this session is Haney, H-A-N-E-Y, H-A-N-E-Y. Okay, so put that on your list of code words to email to us at the conclusion of the seminar. We do have one question in the chat. What are your thoughts on the Brackeen-Ikwa Indian child welfare case that's going to be argued November 9th in front of the Supreme Court?
That case scares the heck out of me for exactly the same reason that I am offended by what Governor Stitt said on Fox News. Governor Stitt on Fox News said that this is all about race. And then he went on to say that tribes lack the characteristics of legitimate governments. I think it's worth noting the Supreme Court has repeatedly said, including in Morton versus Mancari in 1974, that tribes, when the federal government acknowledges tribes, it is making a political distinction, not a racial categorization, but recognizing political status as a member of or citizen of an Indian tribe, a political sovereign. I think it is racist to refuse to acknowledge the political status of tribes and insist that tribes are never anything more than a race or an ethnic group. That's as literally racist as I can think of, that the court categorizes them lawfully as something else, and then the state refuses to recognize that federal classification and instead keeps insisting it's only about race. Well, when I think about Brackeen, which has, which embodies certain groups like the Goldwater Institute, who have made it their mission to destroy the Indian Child Welfare Act, I think it's, again, really troubling, because if you go back to the Baby Veronica case, you can tell where the court is going in that case at the very beginning. In the first or second sentence, they note that that child is only 256th Cherokee. In other words, the court was thinking only about race, not about political classification. Further, the Indian Child Welfare Act of 1978 expressly acknowledges that there are more concerns in this area than just the well-being of an individual child, that there are also community concerns, and that the integrity and health and well-being of tribal communities historically targeted by the federal government for destruction was also a valid consideration. That's why the Indian Child Welfare Act creates a priority of keeping the child with Native parents in the Native community. And so I am quite disturbed that the current court might, like the baby Veronica court, think only in terms of race and not in terms of political status. Now, if they hold the way the Fifth Circuit, or if they hold that it is racial discrimination, that poses the risk of tossing all federal Indian law up in the air and disrupting just about every part of Indian law that I can think of. Then the court will have, yet again, sort of more power to make Indian law what it wants to be rather than relying on Congress. And I guess just in closure, I think we have a systemic problem in federal Indian law, because what courts are good at is taking a text-based standard and applying it to a set of facts ex post facto to determine relative rights. But in this case, we've got inherent tribal sovereignty, which predates the Constitution, so there's no text that defines the minimum amount of tribal sovereignty. Likewise, Kagama tells us that federal plenary power over Indian affairs is not found in the Constitution. It is extra-textual, just like power over immigration is extra-textual or extra-constitutional, which means there's no text that tells the maximum amount of federal authority. And since states had always been excluded, there's no text to define the maximum amount of state authority. That gives a shocking amount of power to the court itself. The court has taken that power and it's now using it in ways that I find to be frightening and disturbing as departures from precedent, from separation of powers notions, and from internal logic.
All right. Just one question also, and this is coming up, and actually it came up again in a case that I'm going to cover in my materials as to who's an Indian. Are you aware of any other governments anywhere around the world, any nation that requires to be a citizen of that nation, they have to have some inherent blood? You know, for example, an example I always use is England. You know, anybody can move to England. Doesn't matter if you're English or if you're Chinese or if you're Pakistani or whatever. If you satisfy the requirements of becoming a citizen, are there any other governments that you know, are scrutinized in the same fashion? In other words, you got to have some blood tied to the original inhabitants of that location.
Not that I know of. Israel comes to mind a little bit there. Now, England opened its rules up because of the empire and the Commonwealth, but you're right, you can be a naturalized citizen in any nation. I think tribes also have the power to, under their own laws, to naturalize citizens. And then it's purely a question of citizenship. United States versus Rogers is an example of that. An 1860s case where a non-Indian married a Cherokee citizen, got Cherokee citizenship, and then committed a crime. I think it was murder against another, a full-blood Indian. And there the court said that race was, or that citizenship wasn't the factor, race was. And the federal government still had jurisdiction over that guy because it was an interracial crime. Now, we got less comfortable with that language. And so Morton versus Mancari tries to anchor congressional plenary power in the Constitution. And then in 1977, in United States versus Antelope, where someone was bringing an equal protection claim saying, you know, if I was non-Indian, I wouldn't be subject to the death penalty, but because I'm an Indian, I'm subject to federal jurisdiction, which has a federal a felony murder rule and the death penalty. And the court said, you may be subject to federal jurisdiction because of your Indian status, but you are treated exactly like everyone else who is subject to federal jurisdiction. So there's no equal protection problem, sort of skipping over that issue, but still drawing this distinction, this time saying race has nothing to do with it. It's all about citizenship. Now, those two cases are still good law. So the 10th Circuit requires for criminal jurisdiction purposes that you have some degree of Indian blood and at least be eligible for membership. So they're trying to make sense of these two internally inconsistent Supreme Court cases. But there are two kinds of jurisdiction that come up in this context. Territoriality-based jurisdiction, clearly within geographic boundaries, somebody has the power over people and property, and nationality-based jurisdiction. You might think of the ancient Roman Empire where Roman civil law applied to everybody, but for certain groups like Jews, for example, they had power over marriage, probate, and sort of internal relations. So there were a separate set of rules that governed some things, but there were other rules that governed more generally. So in the United States, we almost always rely on territoriality-based jurisdiction. Indian law is sort of the one exception to that I can think of, where under the Indian Child Welfare Act, for example, wherever you are, if it's a certain custody proceeding dealing with an Indian child as defined by the statute, not defined by race, then those special rules apply. So I can't think of a modern national government where this comes up. But to come back, as you said, in a place like France or Great Britain, if you meet the requirements for citizenship and you become a citizen, then your race is an irrelevant question. But in the United States, there are still people who really seem to cling to the idea of tribal dependency and the idea that the less dependent tribes are, the less nations they are, I think, but also to insist on looking through the tribal sovereign and only looking at the individual from a racial lens. And so I'm worried about Burkine for that reason.
All right. Thank you for those comments. Just one final thought, and then we'll move on to our next speaker. I think we're a little bit over, but this is good discussion. There is precedent, for example, the Seminoles. Seminoles have 2 bands out of their 14 bands who are freedmen bands who don't have any Indian blood, yet they are tribal citizens. They're entitled to receive benefits as a tribal citizen. My own tribe, Kiowa, in our constitution, we include what are referred to as captives. In other words, tribes other than the Kiowas that were captured or forcibly adopted into the tribe, including Mexicans and non-Indians and other tribes, are treated as full citizens. So, this concept of this blood is kind of a misnomer, as you stated, and it's continuing to cause problems. There was one question that in the chat about the Hooper case. I'm going to be discussing the Hooper case in my presentation, so we'll take that up then. I think we'll move on to our next speaker if we're ready. Our next speaker is Stacy Leeds. She's a professor of law and leadership at the Sandra Day O'Connor College of Law in at Arizona State University. She's a scholar of Indigenous law and policy and has a law degree from the University of Wisconsin and the University of Tulsa, a business degree from the University of Tennessee, and an undergraduate history from Washington University in St. Louis. She was the first Indigenous woman to serve as a law school dean. That was of the Arkansas School of Law from 2011 to 2018. She's also been an administrator and professor at the University of Kansas, University of North Dakota, and the William H. Hasty Fellow at the University of Wisconsin. She's been the recipient of the American Bar Association's Spirit of Excellence Award. She's also former Cherokee Nation Supreme Court Justice, former chair of the Cherokee Nation Gaming Commission, and many other attributes and accolades here that are quite extensive. So without cutting into her time anymore, I want to turn the presentation now over to Stacy Leeds.
Thanks, Arvo, and good afternoon, everyone. I want to start off with thanks to the Oklahoma Indian Bar Association for getting us all together on a Friday afternoon. ARVO, of course, runs a really tight ship, so I have some marching orders of the things that I'm going to cover. I'm going to first pick up where Ty left off with Castro-Huerta, and then talk about places where that case may take off in other areas of the law, and discuss whether there's been any mileage with the very broad sweeping language that Ty talked about in the majority opinion. I'm then going to talk about two other topics before I open it up to questions. One is just the mechanics of the allotment process and how those processes and the understanding of the allotment agreements and the Curtis Act are going to be very relevant in our tax context, as well as some of the arguments that are being advanced about where the power lies or not with the municipalities within the state of Oklahoma. And then finally, I'm going to end on where Castro-Huerta leaves Public Law 280 states and the tribes there across the United States. So first, let me pick up with the Castro-Huerta discussion. Remember that at the time that the underlying charges were initiated by Oklahoma in this case, it was before Murphy and McGirt, right? And there was only one issue that was presented to the United States Supreme Court in this case, and that is this question about whether the state has concurrent jurisdiction with the federal government or not over crimes where the defendants are non-Indians. Now, remember at the time that this case was initiated, there were only two possible options for the sovereigns that could have prosecuted this person, right? And so there was state prosecution, which at the time these charges were brought, Oklahoma thought that they were the only court of general jurisdiction, and they presumed that it was just their bite at the apple, right? And the federal government at the time was deferring to the state to go ahead with those prosecutions. But we know because Castro-Huerta was a non-Indian, there was no instance during the early days of the discussion of this case where any of the tribes could have prosecuted him for these crimes that took place against this child, right? A native child. And so, you know, getting back to the underlying case in this context, remember it's a non-Indian who committed a crime where there was severe neglect against his stepdaughter, this 5-year-old native child, a member of the Eastern Band Cherokee. Now, after Murphy went to the 10th Circuit, remember there were a lot of these defendants who were filing their cases for post-conviction relief in the Oklahoma Court of Criminal Appeals, and those were being held while McGirt was being decided. But then after McGirt comes out, if you'll recall, there was this mass remand of all of these post-conviction cases that Murphy and McGirt implicated, and they were sent back down to the district courts in Oklahoma where those prosecutions took place, and two questions were posed to that court. And I know Arvo is going to pick up the Indian question here in a moment, but the question that got asked of that court is, did this case involve Indians, and did it take place inside of Indian country? Now, for all the tribes, after the Muskogee Creek Nation, these were the local federal or state district courts where the reservation boundary cases were put on, right? So this is how each of the other of the 5 tribes, and then eventually Quapaw and others, had their boundaries re-recognized by virtue of those criminal cases that were similarly situated to this one. So the Cherokee Nation reservation boundary gets argued in this case, and at the time, if you talk to the attorney generals for the Cherokee Nation and the attorneys that worked with them, the state didn't really contest the boundaries, right? The tribes, as amicus, put on all of their documents to make a record for what would eventually go up. But the Cherokee Nation reservation adjudications came in that Hogner and Spears case, but this was right there along with it. 2021 is where the Cherokee boundaries were re-recognized. But, you know, before the Castro-Huerta case goes up, Oklahoma Court of Criminal Appeals has that case, and they ruled that the federal government has exclusive jurisdiction over these crimes committed in Indian country, where the defendant is a non-Indian and the victim is Native. It was that basic General Crimes Act jurisdiction discussion that had been the law since the 1790s, because it goes back to this first treaty language, right? And the only exception up until that point had been where there are crimes where two non-Indians are involved, right? Non-Indian on non-Indian crimes. You'll remember the case of United States versus McBratney, 1881 out of Colorado. And the argument there, which was relevant to some extent in Castro-Huerta, was that the states have an interest when two of their own citizens commit a crime against each other, right? And that it would breach notions of constitutional equal footing doctrine if we didn't allow some states out west, where Indian country exists, to prosecute those same crimes that of course would be prosecuted in the states that came into the Union earlier, right? So the state has this profound interest in prosecuting that non-Indian versus non-Indian cases. But there was something else at issue in that McBratney case, and that was there's a lot of treaties that talk about crime where non-Indians are committing crimes against natives, right? Or where the reverse is true. And in those contexts, the federal government has an interest and the tribes have an interest. And then it's that language from all of those treaties that lead to Congress codifying them in the General Crimes Act, right? And so all of that is part of this understanding, or with the majority's opinion in this case, the misunderstanding of how deep that federal preemption plays out from a treaty right to a statute in these cases. Now, what I want us to ponder today is, with that background, what would happen differently if Castro-Huerta happened today, right? So here we are, October 14th, and we're 2 weeks after this big October 1st go live date of the Violence Against Women 2022 provisions that pertain to tribes. Now, I know later on in our afternoon, Kara Bacon from Choctaw Nation is going to talk about VAWA, so I'm not going to steal her thunder, but I'm going to take it in the context of just this case and start to think about how the arguments are even different now than they were at the time of this case, as another reason why I think this case can be put into a box to some degree, okay? So, the 2022 VAWA reauthorization extends the concept of what constitutes a covered crime under the statute. If you go back to the early days of VAWA, the congressional interest was, let's create a situation where a person who needs a protective order or a person who's then a victim of domestic violence doesn't have to interact with a bunch of different court systems before they can get protection and eventually justice. Let's have a comprehensive federal scheme across states, tribes, and the United States Attorney's Office who prosecute these interstate type crimes. And let's make sure that this is one seamless network where it's not too difficult for victims to navigate. Then as part of that, in the 2013 VAWA, we got the first time ever this Oliphant fix that gave very limited special jurisdiction, recognized very limited jurisdiction in tribes to prosecute just a certain kind of crime, the domestic violence related crimes. The 2022 edition of VAWA says, we can't look at these circumstances in a vacuum and think that there's not all of these other activities and crimes that are going on that are interrelated. So they expanded the crimes that now a tribe is recognized as having authority to prosecute a non-Indian, like the defendant in this case, who commits certain kinds of crimes. Now, I'm going to focus on two of those kinds of crimes. And the first one I want to focus on is, it now says that a tribe could prosecute crimes of child violence. Non-Indian perpetrator, victim is a Native child, right? Now, you scratch your head for a second, you think about this case, and it was a neglect case, right? But it was such a profound neglect case that serious bodily injury occurred to this child. Now, one of the things that I think is most amazing about this 2020 VAWA statute is it does a lot to defer to and incentivize the growth of tribal law in a way that maybe we haven't seen in a while. If you think back to the Indian Child Welfare Act, it has these kinds of provisions in it that says definition of an extended family, right? It's not for the feds or the state to tell us what an extended family is. So in the federal statute, it says we look to the tribe's laws to determine what constitutes an extended family. Well, in the VAWA 2022, they did the same thing. And they said, we are going to look to how the tribe defines certain offenses. And then that is going to be the offense that they, it's various different categories. And so they didn't spell out in each of these covered crimes the underlying cause of action, the underlying offense. That is left for the tribes. And so as I understand it, although it may have been an oversight, part of the distance to October 1st was to give the tribes the opportunity to scale up, like Kara's going to talk about in a bit. So when it comes to child violence, right, that can be defined in many different ways by a tribe. So I've looked at tribal codes and I see situations where child violence is defined as domestic violence within a certain proximity of a child, right? That even that child was not physically beaten during that altercation. That child is going to suffer such trauma as a result of being in that location that it might be defined in the code by violence, right? And then other ways. When you look at how horrific this underlying crime was in Castro-Huerta, I do very much think that this is one of these situations that if a tribe broadly defines what constitutes child violence in their tribal code, now they create a situation, Castro-Huerta happens today, and it's not just that the feds have jurisdiction under the General Crimes Act, but now the tribe also has jurisdiction under the 2022 VAWA provisions, right? That wasn't the case at the time Castro-Huerta originated. And so I think it begs the question, is it automatically the case that the state would also have jurisdiction so that all three sovereigns are now in this space? Or is the fact that there is additional congressional findings that this ought to take place at the tribe and or the federal level for public safety, for report backs to the tribe and other federal/tribal interest, the kind of interest that you see in the preemption and the Bracker balancing test cases tend to push the state out of the equation, right? Now, do I think that this current Supreme Court would get there? No. I think the current Supreme Court would still presume that all three sovereigns have jurisdiction in the case. And it sure makes it messy on the ground to try to figure out, is there an agreement that the tribe's going to enter into with a particular county to say who goes first? Is there understandings of prosecutorial discretion that domestic violence cases, the tribe gets the first pass at? Does it depend on the severity of the crime? So there's a lot of things obviously happening on the ground, but I throw that out there because I think that now after October 1st, we're in a very different world as it relates to the preemption analysis and to the question about what sovereign has legitimate interest in the prosecution of this particular case and how. And so keep that in the back of your mind. The other piece of it, in addition to the child violence, is that the VAWA 2022 has provisions where the assault on a police officer can be prosecuted in the tribal court, right? And the rationale is this: 911 call, people respond to a domestic violence and or child violence and or trafficking situation. And in that process, there's an assault on the tribal police officer. VAWA 2022 says the tribe can prosecute that non-Indian perpetrator if the victim is that police officer. And understand, those of us who all work in Indian country, you know that 100% of the law enforcement at some of these tribes is not all Native individuals. So it puts forward the situation, probably for the first time ever, at least since McBratney, right, in the late 1850s, that the tribes can now prosecute a situation where both the defendant and the victim are non-Indians, as long as it's in this particular context. right? And so again, was it contemplated that all three would be in the mix, or that it's tribal federal? And I think that those kinds of discussion are part of this, I guess, new balancing test that exists. So I wanted to mention that as far as taking Castro-Huerta today and the many things that change both for that preemption analysis and other ways. And think about what that means. If we come to a place where now all three sovereigns can prosecute a crime against a non-Indian, let's think about how each of those sovereigns comes to that space. And I think that that's very telling, right? Two of them come to that space because Congress expressly provided for their jurisdiction, the federal courts and the tribal courts. The state comes to that space newly because the United States Supreme Court, for the first time ever, said that they have that authority, right? And so again, toward that preemption analysis and clarification in future statutes, I think that that certainly begs the question. In my research, the only situation where Congress has ever provided that there be jurisdiction resting in all three sovereigns in a criminal law context is in the state of Kansas with the Kansas Act. The Kansas Act gets passed at the same time frame policy-wise as some of the termination era acts, and at the same time as Public Law 280. But what's very different about Public Law 280 and the Kansas Act is that the Kansas Act has this final clause that says, yes, we're giving over to the state of Kansas the authority to prosecute these crimes. However, nothing in this act does anything to prohibit the U.S. Attorney's Office for continuing to prosecute federal crimes that happen inside of Indian country in the tribes, the 4 tribes there in Kansas. And then subsequently, we've had rulings that Public Law 280 takes some power that the feds normally exercise and extends that over to the state, but it couldn't be read to completely stamp out the tribe's inherent sovereignty because it's silent as to the tribe. And our presumption in federal Indian law all along is that tribes retain inherent power that any other sovereign would retain unless and until it's given up in a treaty or taken away by Congress. And so it's not expressly taken away in either the Public Law 280 or the Kansas law context. And so you continue to have this situation in Kansas by federal statute that all three are in the mix, okay? Now, again, I wanna circle back around to the native child victim example that I talked about and put a plug in for those of you on the call that have not revised the tribal code to implement VAWA. Make sure that you write your language as broad as possible and that child violence can mean many, many, many things, right? And some tribes have started to circulate their codes. And so certainly a severe neglect that rises to such a bodily injury scenario, I think that that could be fit in a way that would be upheld as far as the language of the statute, okay? With that, I want to shift over to the other types of places where the decision in Castro-Huerta has started to grow legs even in the short amount of time since it's been out. And I'm gonna shift now over to the taxation space and all of the pending claims before the Oklahoma Tax Commission. So 10 days ago, the Oklahoma Tax Commission issued its en banc deliberation decision in the Strobel case. And both the original case that came from the administrative law judge with his facts and conclusions and recommendations to the Oklahoma Tax Commission, and now the Tax Commission's full decision on this case, they are both on Turtle Talk, but the Oklahoma Tax Commission piece, we have put that in the Dropbox for this CLE's materials so that you can read that. So the prior findings of fact and conclusion of law in this case, procedurally, before the Oklahoma Tax Commission, you get a hearing before an administrative law judge. That decision of that ALJ is not binding authority on the Oklahoma Tax Commission. It is a finding and recommendation to the panel as to what the facts and the underlying law should be in that case. In this case, the ALJ looked at all of the tax cases from McClanahan versus Arizona to present and made the determination that McGirt redefined or re-acknowledged the boundaries of the Muskogee Creek Nation in that they have never been disestablished, and therefore it was Indian country for reservation boundary purposes. And if it's Indian country for reservation boundary purposes, then it places the tribes in Oklahoma on an equal footing as the tribes in any other state as far as taxation goes. So McClanahan versus Arizona and all of the cases that came after that go with that same presumption that I just described that says states are presumed not to have authority inside of Indian country, absent some statute from Congress that invites them in. And the ALJ concluded that Oklahoma lacked authority to tax the income of tribal members who live within their tribe's reservation boundaries or Indian country, so long as the income is also derived inside that same territorial boundaries. Now, what's interesting about this case, and allegedly there's 9,000 of these cases from various years pending before Oklahoma Tax Commission right now. This first case deals with the tax years 2017, 2018, and 2019. So it's the 3 years immediately before the McGirt decision came down. And it does not implicate the tax year 2020, which July 9th, 2020 was when McGirt was decided. And so this case does present the question to the OTC of what happens with these prior cases pre-McGirt? Do they get treated any differently? And so, you know, it's important to note that even in this OTC decision, although it's clear what they're going to do with these future cases too, it really is this single issue of prior to McGirt cases. And they, you know, overturn and reject the recommendation of the ALJ. What the Oklahoma Tax Commission says is really remarkable on some ways. So I'm going to walk through it a little bit and then talk about some arguments that I think might be relevant on the appeal process. The Oklahoma Tax Commission says that McGirt was only about the Major Crimes Act and nothing else, right? So to the extent that the reservation boundaries exist, they only exist for purposes of the Major Crimes Act and prosecution of those crimes by the United States, right? But they definitely cite to Castro-Huerta's majority opinion for the proposition that McGirt only applies, you know, in this small context, and that Oklahoma has broad jurisdiction otherwise. One of the other fairly older cases in federal Indian law that the Tax Commission cites to, which I think is incredibly dangerous, is the Sherrill case, right? Sherrill case was one of the cases dealing with the land claims out of New York and whether there were land claims that still survived based on violations of the Trade and Intercourse Acts, right? That Indian land is not supposed to be purchased by a state or an individual, only by the federal government. And that if you rest on those claims for too long, equitable principles apply. And there's a point in time where you're just cut off from making those old arguments. So the Oklahoma Tax Commission cites Sherrill, and probably the most offensive language in the decision is this. They cite Sherrill and say that you have waited too long to make these arguments, not this particular petitioner, but tribes in general have waited too long to make these arguments, and that the, quote, ancient sovereignty, end quote, of the tribes that was revived by McGirt is not going to be extended to taxes, right? That if you waited too long and Oklahoma's been taxing you all this time, then that's the end of the discussion and we're not going to now magically stop taxing. And that's so interesting because for me in McGirt, the part of the decision that was such powerful language is not that first sentence that talks about at the end of the Trail of Tears was a promise. It's the language that talks about if you are so brazen in the exercise of your unlawful jurisdiction year after year after year, and we do nothing about it, it rewards the lawlessness and, you know, denies justice from people who are entitled to it. And it's that same sort of argument. It's like, this has been going on too long. There's a point in time where you have stale claims, you know, that courts or agencies like this one won't listen to. The other thing about this, and this is, of course, a redacted version of the denial, but it's published as a precedential decision for the Oklahoma Tax Commission. One of the things that was at issue is the protestant in this case made a lot of arguments around the Oklahoma Tax Commission's report that was issued in September following McGirt. And that report talked about, okay, now if McGirt applies to taxes, here's going to be the impact in Oklahoma of that. And the Oklahoma Tax Commission was very clear that they do not recognize that report, right? And that they said that it was issued by a former executive director who was the signatory on that report, but it was never an order of the commission itself. Therefore, you can't cite to it as any sort of authority because they reject that order is an order of the Oklahoma Tax Commission. All right, so a little bit else about this particular case, because I think facts are so important in these tax contexts. The petitioner in this case is somebody who lives inside the Muskogee Creek Nation boundaries, but lives on fee land, not on trust or restricted property. That was a very important piece for the Oklahoma Tax Commission in their decision. And it's someone who is an employee of the tribe. So some of the arguments that get presented in tax cases throughout the years talk about individuals who derive their income directly from the tribe, right? That there might be some Williams versus Lee type argument that they're carrying out the governmental function of the tribe. So in addition to that individual's rights not to be taxed, there's also an implication of the sovereign rights of its own nation if their employees are then encumbered by this other sovereign, where the paycheck in between the tribe and that individual never touch that state, right? And so she is an employee of the tribe. Now, when it talks about the particular status of land, I want to pick back up on that one for a moment. Now, in all of these cases, it's clear that the person who's making the challenge is the party that has the burden of proof. It's only a preponderance of evidence before the tax commission, but it's the burden of the party to show that they in fact live in their tribe's Indian country and that the income is derived there. And so, you know, the focus of the tax commission on the underlying status of land, they're of course looking for deeds and other type of conveyances. And because they reject that the boundaries are relevant for things beyond just the Major Crimes Act, then the Oklahoma Tax Commission has stepped back to its old position that the only way this protestant could win is if she showed that she was on Indian country under 1151 B and C, either trust or restricted property or a dependent Indian community, because A is out of the question if they don't recognize boundaries beyond the Major Crimes Act post McGirt. And I think that it's very interesting because both for the taxation questions and for the alleged power of the municipalities, Curtis Act to the Allotment Acts to present, this status of land question keeps coming back up, right? And I think that it's an important one because I think that many of us still miss the boat when we talk about types of land tenure in Oklahoma, particularly that of the 5 tribes, because the tax commission and others focus so intently on this fee title issue that it's misplaced because it is asserting that something has happened to reclassify that tribal citizen in some way that hasn't happened. And here's what I mean by that. In Castro-Huerta, when they basically say that Worcester, as we know it, is dead, right? That long ago we stepped aside from that. Well, in other tribes outside of Oklahoma, That is true in some sense because of the allotment process. And here's how the courts have developed that over time. Even Worcester says that absent the tribe giving up their power or Congress saying something to the contrary, that the power of the tribe and their territorial boundaries mean something. The later cases say essentially that once the allotment process started to take hold, and it created a situation where non-Indians eventually became the title holders of fee land inside of Indian country, that Congress set that in motion knowing that that was going to happen. And eventually you get to cases like United States versus Montana, where the focal point is, does the tribe have the power to exclude that non-Indian person? And if they don't, they probably don't have the tribal sovereignty power to regulate that person on that particular land. But in the tax context and then the municipal context with Native Americans, it's the reverse presumption, right? We're not talking about non-Indians. We're talking about natives in their tribe's own jurisdiction. And the fact that a Muskogee Creek or Cherokee person is living on a piece of fee land is almost laughable in an almost obvious sense, in that the mechanics of the allotment process, the tribes here in Oklahoma, the 5 tribes, never had their land in trust, ever, right? It was fee title from the time that they were removed here. It doesn't get put in the United States trust and then eventually, it goes to non-Indians. The mechanics of the allotment process is that those deeds pursuant to the allotment agreements are the principal chief as the grantor to tribal citizen as the grantee in fee, right? It was fee the night before allotment, it's fee after allotment, okay? Now, it's held in fee and it's subject to restrictions that are put on that piece of land by statutes, right? By federal law, but the underlying estate has always been fee land since removal to the present day. So it's as if the tax commission wants the tribes, the 5 tribes that hold their land in fee, they're asking that those individual tribal members hold it in a more Indian way than they did the day after the allotment process. And it's interesting to me that in this Oklahoma Tax Commission decision, they make a real point about pointing out that this petitioner lives on fee land and therefore it can't be Indian country, and that she purchased or acquired the land from a non-Indian grantor, okay? Now, what they're doing there is they are setting this up for an extinguishment of Indian title by selling something to a non-Indian person, right? So it's just not reservation boundary because they said so, and then there's something wrong with the fee land. If you take many, many, many other people across the state who are members of their tribes that took an allotment from the principal chief to the tribal citizen, and now it's been in family members or purchased citizen to citizen to citizen to citizen, there are many pieces of land like the one that I'm zooming into you from today that have a consistent chain of Indian title from the old days to present. And I think that we need to start making that point regularly because Congress has done nothing besides open it up to oil and gas regulation and ad valorem tax in the 1947 Stigler Act. Otherwise, nothing has been said that would open up and invite Oklahoma to this. And so Indian country in the 5 tribes is much more complex than this 1151 A, B, and C as it relates to taxes and other regulatory types of discussion. But they pointed that out, and it also was an issue in the Chickasaw Nation's reservation boundary case. There was a crime that took place in Purcell, Oklahoma, and the case talked about the fact that that allotment had been preserved from the time of allotment to now in continuous Chickasaw occupation, right? That there hadn't been a break in chain of title. And so, it's always like these very little sprinklings, but that theory is starting to evolve for better or worse in a lot of these cases, and this tax commission case is no different. Okay. And then finally, I'll mention just a few takeaways from this tax case. Number one, it leaves open all of the claims for tax years 2020 to present, the post-McGirt tax claims. It certainly shows the tip of the hand as to which direction the commission is heading in those, but those issues are not automatically resolved with this case. The second piece was what I just mentioned, that Oklahoma Tax Commission took a bite onto this issue of succession in interest of Indian people on that tract of land from the time of allotment. And again, that's important for us to understand those full mechanics, because the whole of this argument about municipalities in Oklahoma somehow holding this superpower, right, that is much broader than what the state of Oklahoma itself has, as derived from some language in the Curtis Act, but probably taken away under each of the allotment acts. Understanding these mechanics did not go away with McGirt, they accelerate with McGirt. And I urge you to go back in whatever tribe you're working on and read that treaty again and read the allotment act again, because several of these allotment acts, which were used as coercive documents, right, to get you to sign on to the agreement, we were going to do this, this, and this from the federal government if the tribe doesn't sign on to it. A lot of those allotment acts undo expressly things that were temporary or threatened in the Curtis Act. And so look for those. And then finally, I want to talk about this argument in Castro-Huerta where they talk about Worcester basically being dead, right? And I think that that is true when it comes to non-Indians. It is not true at all when it comes to natives inside of Indian country. And so, you know, when you hear people talk about Castro-Huerta, if we can all just add an additional comma and insert some language as it relates to state power over non-Indians, that's what Castro-Huerta is all about. And so keep saying that phrase, you know, over and over. The other thing that I want to talk about is that this tax commission case and Castro-Huerta are not treaty cases. They're not talking about treaty rights. I'm sure that there's treaty right arguments underlying that challenge, but the Oklahoma Tax Commission gives no discussion as to treaty rights, right? And Castro-Huerta also is not a treaty right case, because although there's some very good language of the Cherokee Nation in the 1866 treaty, there is not language that would suggest that the tribe, to the exclusion of the state, would have jurisdiction over a future state, would have jurisdiction over non-Indians. But there is very express language in that treaty that keeps exclusive jurisdiction, civil and criminal, when there are people of the Cherokee Nation, regardless of their race, but citizens of the Cherokee Nation, that would stay. And so make sure that you very, very closely read each of those documents one more time. In the last 5 minutes, I want to mention one treaty issue and then talk about Public Law 280. It is rare that these treaties mention the word taxation, but sometimes they do, right? In the Herrera case out of the United States Supreme Court, that was the hunting and fishing case. The one that was in Washington, it'll come to me in a moment, you know, it talked about the ability to travel freely outside of the reservation, and by implication, it invoked taxes. But the Cherokee Nations Treaty of 1866, if you take a look at Article 10, it actually contemplates expressly that individual Cherokees should not have a restraint on their sale of merchandise or of their trade, right? So i.e. your ability to make income. And the treaty expressly says that so long as that, you know, trade or commerce that the individual Cherokees are doing, as long as it doesn't go outside of Indian territory, not outside of Cherokee Nation, but outside of Indian territory, that they're not supposed to be compromised in any way, even by the United States. So there's a treaty right not to be taxed by the United States, certainly not to be taxed by a state that's not contemplated at that time. So take a look at that. But it really begs the question in my mind about this difference between treaty rights that individual tribal citizens have versus treaty rights that the tribes have. And that we need to be clear in our explanation and assertion of both of those. And, you know, when it comes to, you know, Supreme Court cases, there's the Menominee case out of the 1968 and then into the 80s. You'll recall that Menominee was one of the tribes that was terminated, expressly terminated. They have now been restored. But when they were terminated, they took a claim to the United States Court of Claims and said, okay, if you've terminated me and I as a tribe have no more rights, then you need to compensate us for the hunting and fishing rights, which are compensable property rights under our treaty. And the Court of Claims said, no, there's no right to be compensated because those hunting and fishing rights still exist in your people, right? So it created this situation where even if the United States does not recognize the political entity that is your tribe at this moment, that treaty rights can be individual as to tribal citizens, and they can be sovereign rights that are, you know, afforded the entity itself. And so I think as we get into these income tax cases and these individual criminal cases, it is quite possible that an individual has a treaty right that is distinct and different than the tribe's treaty right, right? So that example that I just mentioned out of Article 10 of the Cherokee Nation Treaty, it's talking about Cherokee individuals' rights not to have their income encumbered by another sovereign, right? So that's an individual treaty right. And in the context of, you know, the Public Law 280 context, when the cases came up after that Court of Claims, they said the tribe doesn't have a right to be compensated because those still exist in the individuals. And then Wisconsin started trying to criminally prosecute people for hunting and fishing inside that state. And those challenges were this: the individual Menominee people say, the state can't prosecute me, even if it's a Public Law 280 state, because they can't tell me that I can't exercise my treaty rights, right? And so that was the revival of individual treaty rights at a time that even the political entity was viewed to be dead by the United States. And so keep those things in mind, because, you know, there's tribal rights that are going to be argued and advanced in a very different way than what individual rights. There was mention at the beginning about the individual citizenship rights of freedmen inside the Cherokee Nation. It also came up a lot to me in the immediate aftermath of the Cobell litigation. I was one of 5 people on a task force to look at reform of the trust administration system. And the single biggest takeaway that I had from those listening sessions all over the country is that when it comes to tribal land, the tribes can very much be on one side of the table and the allottees can have a completely different viewpoint as to stewardship and use of those land rights. And so those two things, you know, might collide slightly differently, whether it's what tribes are asking from Congress or whether it's the way that an individual might advance their tax claims different than the tribe's claims about interference with their sovereignty. And so I just want to put a pin in that. I've got a couple of minutes before I get to the question and answer. I'm going to just point you to a couple of references that are really important. In the Castro-Huerta hearing before the House Committee on Natural Resources several weeks ago, take a look at Carol Goldberg's testimony about Public Law 280. She has been studying this stuff, of course, for 50 years. And her discussion of weaving in Public Law 280 along with how the majority opinion in Castro-Huerta just plain got it wrong was absolutely masterful. But one of the things that she talks about is, you know, the whole point of Public Law 280 was that Congress believed that the states never had this power. And so Congress had to step in and give over that power to some states because they didn't have it to begin with, right? And that eventually there became a point in time where there was a mechanism for tribal consent, right? That there could be new Public Law 280s so long as the tribes agreed. And that there's never been a tribe that has agreed to it since that mechanism became, operable under the statute. But the other thing that she talks about, instead of just this intellectual dishonesty, question in that opinion, is what does Castro-Huerta do to the currently existing Public Law 280 states? And now they have double jurisdiction, right? They've got it because apparently they already had it, plus they're a Public Law 280 state. But what happens if the tribe and the state reach a retrocession agreement where the state steps out of it and then the tribe takes over retrocession in whole or in part, as we've seen all over the country? And Castro-Huerta really throws a wrench in that, right? Because can a tribe that spends the resources and takes on retrocession of jurisdiction ever be confident that that's true? Because even if there's a retrocession of Public Law 280 jurisdiction, Castro-Huerta says that that state already has this jurisdiction anyway, right? And so the next political administration comes in that state and just starts exercising Castro-Huerta jurisdiction, right? And so I think that this is part of the very complicated and nuanced question of why it's so difficult right now for all of Indian country to get behind what to do next after Castro-Huerta. There are times where tribes all come together, and the Brackeen situation right now is one of those. But when I go all over the United States throughout Indian country, nobody's on the same page on this, right? Because everybody's impacted about it differently, and tribes are impacted about it differently, even county to county and city to city within their own jurisdiction. And so it's complicated and unnecessary stuff, but here we are. So I've got about 7 minutes, I think, for any questions that I'll take. Only two things. In addition to the Carol Goldberg testimony that I would ask you to take a look at, there are two new law review articles by Dylan Heading Nicely. He's a Cherokee citizen who's a law professor at Idaho Law, runs their Indian law program there. But he's posted two of his pieces about Castro-Huerta on his SSRN page. And I think you should take a look at that. One of them is called "The Reports of My Death Are Greatly Exaggerated, a Continued Viability of the Worcester Decision." And then the other is just straight taking on this Castro-Huerta and what happens when there's direct treaty language different than what was at issue in this case. So I'll leave you with those and take any questions. Yes, Cougar Den in Washington was what I was trying to come up with. Thank you.
Thank you, Stacy. While we're hoping for some questions to come up here, the next code word that you need to put in your email to send for your CLE credit is Blue Eagle. Blue Eagle. I guess that's two code words, but that's one of the phrases. Blue Eagle. And again, at the conclusion, we want you to send an email to Oklahoma Indian Bar Association with your full name, your bar number, and the 4 words, and any comments or evaluation response that you might provide, since we have to submit that to the Bar Association for official credit. Okay, any other questions? I'm going to talk a little bit about this Curtis Act municipal argument that's popped up out of the city of Tulsa, out of a municipal court. And I haven't had a chance to read the decision of the tax commission that's you were referring to, that's in the Dropbox. Did they mention that at all?
No, they just talk about Castro-Huerta and Cheryl, but they don't get into these county municipality, and no touch on the Curtis Act or the Muskogee Allotment Act. It's a very 10,000-foot decision. It's not very granular.
The other thing that seems very strange is the perception among a lot of state judges here and state officials that somehow Oklahoma is different because, we have a lot of fee land within the boundaries of the reservations. Of course, those of us that have been to other reservations, there are some other reservations throughout the country that are just as heavily allotted, and cases that we have long relied upon from various other reservations that are absolutely, indistinguishable from Oklahoma reservations that were heavily allotted, and there are a lot of fee holdings. I've got some maps that I'm going to show in my presentation that took me a while to gather, but it's a very graphic representation of that. Most reservations, depending on where it is in the country, most of the land is not trust land.
Yeah. One thing that we desperately need, if there's somebody who does this kind of research, it would require, getting out to the county land records and whatnot. But, even when the tribes talk about land base, they will say only 1% or only half of 1% remains. Well, that's not true. Only half of 1% is still restricted allotment or trust land. But if you have 150,000 of your citizens living in your tribe's jurisdiction, a good portion of them are landowners, right? And so there has to be another word and another legal mechanism for the people who, yes, they live on fee land, but they live on Indian fee land, right? And in that, I think there's two categories of people, right? There's the unbroken chain of Indian fee land from principal chief to tribal citizens and all tribal citizens thereafter. And then there's the second piece, which is like the Oklahoma Tax Commission case. Maybe there's a break-in chain where a non-Indian or two have an ownership interest, and then a tribal member regains that ownership interest. Now, I think the courts will say that an individual or a tribe cannot reestablish Indian country by purchasing a piece of land. But for those that are living on trust land that the chain of title has been tribal member all the way up to the present, that has to be a very different land tenure description for legal purposes than just, I'm an Indian and I happen to live on fee land, right? Because nothing has happened to take the Indian character or whatever you want to say out of that land to the degree that that piece of land just gets treated like every other piece of fee land in Oklahoma, right? That is a substantial intellectual leap when you understand the mechanics of the allotment process. So I don't want us to quit making that argument, because I think that that's really important.
Yes, there was a question about the first code word. The first code word was Haney, H-E-N-E-Y. All right, any questions from anyone else?
Okay.
All right, well, thank you,
Thank
Stacy.
you.
I think we're ready to go forward, Joe.
Okay, yeah, my name is Joe Williams. I'm an officer with the Oklahoma Indian Bar Association, and it's my honor to introduce the next speaker, Arvo Mikkonen. He's a Kiowa Comanche attorney, got a Juris Doctor degree from Yale Law School in 1986. After graduating from law school, he served as a law clerk for federal judges at the U.S. Claims Court in D.C. and at the U.S. District Court of the Eastern District of Texas. Arvo is currently an assistant U.S. attorney for the Western District of Oklahoma. He's been in that position since 1994. He was the first designated tribal liaison in a U.S. attorney's office, and also in 1994. From 1988 to 1994, Arvo served as a trial and appellate judge with the Court of Indian Offenses and Court of Indian Appeals for the Anadarko area tribes. From 1991 to 1994, Arvo served as the Chief Justice of the Cheyenne-Arapaho Supreme Court. And on January 2018, he was sworn in as an Associate Justice of the Supreme Court of the Kiowa tribe. Arvo is a frequent instructor for law enforcement and attorneys, having given over 300 workshops, symposia, and instructional seminars. He has also repeatedly served as an invited faculty lecturer for prosecutor training seminars at the U.S. Department of Justice's National Advocacy Center. So it's my honor to introduce Arvo to speak in this next hour. Thank you, Arvo.
All right, thank you, Joe. I'm going to share my screen here. Hopefully everything will run smoothly. Tell me if the slides are showing. Looks like they are. Okay. First of all, standard disclaimer, anything I say is my own personal view. It's not a view of the U.S. Department of Justice, United States, or the U.S. Attorney's Office. I'm going to talk pretty much nuts and bolts, both about Castro-Huerta and VAWA, and my focus is going to be primarily on not what the decisions are or the amendments are, but the implementation. I do have quite a bit of materials to go through. Also, I want to refer you to other items that are on the Dropbox website, including an Indian country jurisdiction chart, the new one that's been issued effective October 1st of this year, that contain the amendments to VAWA, and also contain the amendments made to state jurisdiction as a result of Castro-Huerta. And also there's some other interesting implications for federal juvenile jurisdiction as a result of Castro-Huerta as well. So I'll go ahead and get started. Of course, as Professor Helton mentioned, we start out with the primary Cherokee case, Cherokee Nation versus Georgia and Worcester versus Georgia, that essentially defined the fact that state jurisdiction in Indian country doesn't exist unless Congress provides for it. That's our starting point. Of course, we have many different tribes, some 550 tribes located all throughout the United States, presently that are federally recognized and had original homelands. Many people forget about the fact that when we talk about McGirt, and there seems to be a perception in the general public often that somehow the tribes are getting away with something, or it's a legal loophole or something that they've found upon without prior knowledge of anybody. That is a consistent statement that's been made over and over again. Of course, most of the treaties that you look at least the treaties with the 5 tribes, talk about specific provisions in those treaties that the tribes' land in the West will never be part of any territory, never be part of a state. That's a excerpt from the Treaty of Dancing Rabbit Creek with the Choctaws. And again, here's a quote from the Treaty of New Echota, Cherokee Treaty: "At no future time without the consent will the Cherokee lands be included within the territorial limits or jurisdiction of any state or territory." A lot of people, and this is something that I've been emphasizing recently, a lot of people talk about constitutional rights, First Amendment rights, Second Amendment rights, Fifth Amendment rights, all the time. Well, of course, in the original Constitution, if you go to Article 6, and I don't see, many references to this made in briefing or in public statements, but this is part of the original U.S. Constitution, that all treaties made are the supreme law of the land, and every judge in every state shall be bound thereby. That's in Article 6. Of course, everybody knows that many of the tribes that were removed here, not just the 5 tribes, but other tribes were removed during the Trail of Tears as a result of removal treaties and sometimes agreements, so to speak, with not the entire tribe, but various factions of the tribe. Nonetheless, they were imposed and enforced against all of the tribal members. And the 5 tribes obviously ceded lands and their traditional homelands and were relocated to Oklahoma. In the western part of the state, of course, there were a lot of tribes already here, including my own tribes, Kiowa and Comanches. And again, many of the treaties that were made, and including the one that was referred to that was at issue in Lowell versus Hitchcock, guaranteed tribal lands to the tribes for the remainder of time, and that they could never be taken away unless the tribal members agreed to it. And then the Treaty Medicine Lodge said 3/4 of the adult males had to approve any further land cessions. Same thing with the Cheyenne and Arapahoes and some other treaties. Of course, we have tribes that are removed from other locations, including as far east as Delaware, as far west as the Modoc tribe. In some, there were about 70 tribes that were removed to Oklahoma as a result of removal treaties or agreements or unratified agreements, which caused, of course, over time, Oklahoma just to have a whole variety of different boundaries and borders that changed over time as more and more tribes were moved in as a result of federal policy. Of course, the foothold that took place for the state of Oklahoma began with the area that is outlined in red there, which are sometimes referred to as the unassigned lands. Of course, that's almost a misnomer because those lands had been assigned over and over and over again. But at this point in time, in 1889, there was no tribal government or tribal people that were residing in those areas. And those were the first lands that were opened up to what ultimately became known as the Sooners or the Boomers. This is a snapshot of what Oklahoma looked like in 1889 with the various tribal areas located, portions of the Cherokee Outlet, which is in the northwest part of the state, had been opened already. And then, of course, you can see that central portion, what was referred to as the unassigned lands, were opened as well. Federal policy, as we discussed, changed from keeping the tribal land base in one solid piece, one contiguous area, as a result of allotment that was aimed at opening up reservations, dissolving tribes, promoting farming. And of course, there was a coalition between former abolitionists who sometimes referred to themselves as the Friends of the Indians, primarily religious groups, and railroad interests that paved the way for opening of various reservations to allotment. This is essentially what in 1887, right as allotment began, what Indian country looked like. And you can see, of course, Oklahoma is one of the largest pieces there. The other large reservation area in the South Dakota and North Dakota were the Sioux reservations. Again, there was promotion, most people know this, of trying to deliberately move people onto these lands. These lands were deliberately advertised by railroads, by the federal government, to be opened up, and that's resulted in a lot of these land runs, not just in Oklahoma, but throughout the West. Okay, so with that understanding of the historical background, then we get to the question of how do we determine jurisdiction for Indian country crimes? And I'm going to talk primarily about criminal jurisdiction, but of course, criminal jurisdiction bleeds over into civil as well. And we'll discuss that. So the three things that we look at to determine jurisdiction are the status of the land, the status of the crime, is it a misdemeanor or a felony, and the status of the person involved, if the crime is a victim crime. And we looked at the status of the person as a defendant and as a victim. Tribal jurisdiction is defined by the federal statute, which is a criminal statute, 18 U.S. Code Section 1151, and that's where the special rules that we've been discussing apply. By the construct of the way Congress codified and updated the definition of what is included within Indian country, which happened in 1948, that's still the same law that applies now. And there are, of course, three parts to that. There's 1151A, 1151B, and 1151C. 1151A is all lands within formal reservations. It also includes land within informal reservations, which are basically tribal trust lands. It includes rights of way running through these lands. Every single day, we still get questions. Oh, it's a state highway. It's a state maintained road, and somehow the state has jurisdiction, or the Oklahoma Highway Patrol has jurisdiction on state highways. and somehow the state has jurisdiction in Indian country because of that. That is not correct. Anytime a road, doesn't matter if it's a dirt road or a 4-lane turnpike going through Indian country, it is still Indian country. 1151B are dependent Indian communities. Those are very limited numbers of land in terms of acreages in the state of Oklahoma and elsewhere. And then the Indian allotments, which are maintained in trust or restricted status, doesn't matter if it's trust or restricted land, it's all the same. And it also includes the rights of way, again, going through those properties. Most of the casinos in Oklahoma, I think there are upwards of 120 casinos. I think there's probably about 130 now, are all primarily on 1151A land. And tribal offices and headquarters are primarily on 1151A land, even though it may not be land that was designated by a treaty or a formal agreement. The concept of an informal reservation, which is basically not one of the large land contiguous reservations, comes from these court cases. Oklahoma Tax Commission versus Chickasaw Nation introduces this concept of an informal reservation. Indian Country USA versus Oklahoma. So even for the non-McGirt recognized tribes, those tribes that have tribal trust lands, either their headquarters, cemeteries, casinos, when we go to federal court and we charge those, we're charging those under 1151A Indian reservations, because they're not allotments, they're not dependent Indian communities. So technically every tribe in this state has reservation land, 1151A reservations. That's how we charge it in federal court. Dependent Indian communities was limited by definition that the Supreme Court came up with in the Venati case, which basically says that the land has to be set aside by the federal government for the use of Indians and under federal superintendents. We have very few lands that qualify for that. One of them in the Western District is Riverside Indian School that was set aside before statehood and has been maintained under federal superintendents. It's got its own water supply. People live there, 24/7, year round. So the federal court in the Western District has recognized, and so has the Federal Public Defender's Office, those properties as being a dependent Indian community. And then, of course, the bulk of the land in Oklahoma prior to McGirt that was considered to be Indian country was the 1151C trust allotments. And of course, the restricted allotments. There's no distinguishment between trust allotments or restricted allotments, even though there were cases as late as the 1980s and 1990s that called into question whether or not a restricted allotment was Indian country. That was settled by the 10th Circuit. Clearly they were. Those of you that might have the old Felix Cohen handbook from 1942, if you look in there about restricted allotments, they're clearly listed as Indian country. And that's part of this mythology that somehow a restricted allotment was an Indian country. The state had promoted that argument. And of course, that was finally put to rest. So this is a map that we use in the U.S. Attorney's Office, law enforcement. This shows southwestern Oklahoma, actually lands that are held in trust, either or tribal lands or allotment lands. And you can see this is an area between, at the bottom is Lawton, at the top is Anadarko. So you can see there are lands scattered all over the place. This is in and around Carnegie, Oklahoma. So when we are looking to determine whether or not a crime took place, this is Highway 9 traveling from the east to the west. You can see it goes right through here. This is the Kiowa Tribal Headquarters, but you're going on Indian land, off of Indian land, on Indian land. Sometimes it's one side of the street, not the other. So it's always a first question that we determine whether or not a crime took place on Indian land or off of Indian land, or started on Indian land and then continued elsewhere. This is right around north of Lawton, between Lawton and Elgin. So if you're coming down the H.E. Bailey Turnpike, I had a question about this come up yesterday. Again, the Oklahoma Highway Patrol was saying that the federal government doesn't have jurisdiction over this piece of the H.E. Bailey Turnpike because they have exclusive jurisdiction. Of course, that's incorrect. That's not true at all. So if you're coming down, you've got federal and tribal jurisdiction for this area. If my cursor is showing up, and coming down here on the H.E. Bailey Turnpike, there's a Love's Country Store. This is the Comanche Nation headquarters right here. So again, determining where the Indian land is always an issue that we first have to consider. For those of you that don't know, how do we get to this situation? Of course, historically, as I was discussing during the allotment process, we had original reservations. We had, as a result of all these advertisements and opening of lands, land runs, land lotteries to go into reservations prior to allotment. Allotment process, and this is primarily dealing with the tribes in western Oklahoma and throughout the United States. Some tribes had a different experience. Some of the 5 tribes had a different experience because there wasn't a whole lot of the surplus land left over. The Osage, again, they were treated a little differently, so it depends on what tribe we're talking about, but this is generally what happened. So within these boundaries, allotments were made in very small acreages to individual Indians. And in some cases, after the land was allotted, restrictions were removed based upon blood quantum and other factors, which caused there to be more land that was not in restricted or fee or restricted or trust status in these areas. Of course, some lands were still owned by the tribe. There's a lot of tribal cemeteries or other tribal lands that were reserved. And then we had these various dependent Indian communities. For example, southwestern Oklahoma, you can see in this graphic here, what happened was as the land was allotted, because the pieces were made so small, the allotments only are shown here in the red. The rest of the land was opened by lottery to non-Indians, and that's when you had a lot of non-Indians moving in. And this touches on this question that was brought up in that tax decision that Stacy Leeds spoke about. This perception that somehow Oklahoma is different, which is absolutely not true. You can look at the Pine Ridge Reservation here. These were original areas of the Pine Ridge and Rosebud reservations, and these areas had their boundaries extinguished. Right here, the southeast portion of Pine Ridge, the northwest, northeast, and southeast portion of Rosebud, the boundaries were gone, and it resulted in all kinds of allotments outside of the boundaries of the reservation. Of course, that's Indian country still. But even if you look inside of the boundaries of Pine Ridge, that's what Pine Ridge looks like. It's not one contiguous piece. It's allotted and fractionated with a lot of land holdings inside, just like it is in Oklahoma. Another example is Fort Berthold Reservation. Very little of the land is held in trust. There's a lot of fee land. Same with Cheyenne River Reservation in South Dakota. You can see that there's a lot of tribal land, but there's a lot of fee-owned land within the boundaries of that reservation. So looking at this definition, of course, this is what happened in McGirt. McGirt did nothing, didn't change the law, didn't change jurisdiction, didn't do anything other than change the footprint of Indian country. That's all McGirt did. So because of the way the statute was written, all lands within the limits of a reservation, notwithstanding the issuance of any patent, regardless of who owns the land, if the boundaries are there, the entire area is Indian country as a result of that language. So that's what happened with McGirt. Nothing more, nothing changed other than the fact that the boundaries were still there. Without the boundaries, which is the way it was before, only the colored areas would be Indian country. With the boundaries, then the entire block of land is Indian country. Okay, and of course, then now the question is, all right, so given this land situation, what is the scope of tribal authority in the reservation in the areas that are not either 1151B or C or the A tribally owned trust lands? Of course, McGirt came out and changed the landscape in Oklahoma. I think everybody's familiar with it. Just essentially looked at all the various arguments that have been promoted by the state of Oklahoma and other courts about everybody assumed that the boundaries were gone, that the tribal courts were shut down, that the power to tax was taken away. All of these arguments were raised by the state. The enabling acts somehow gave the state jurisdiction. They talked about, consequences, the numbers of non-Indians to Indians. All of these various factors were considered, and the Supreme Court rejected them, and it resulted in jurisdiction being returned to the Creek Nation over the entire original boundaries, including most of the city of Tulsa. Does McGirt apply only to the 5 tribes? We continue to see articles about that, assumptions about that, and the answer, of course, is no. Other tribes have had their boundaries recognized. Of course, the Quapaws in Oklahoma, there's litigation going on right now involving the Osage and Iowa Comanche and Apache and some other areas in Wisconsin, applying the McGirt rationale. The Oneida Reservation boundaries were recognized and remain intact as a result of a 7th Circuit decision that came down fairly quickly after McGirt. The other argument that we continue to see forward in court is, oh, well, McGirt involved just the Major Crimes Act, and it doesn't involve anything else. It doesn't involve the Indian Country or Crimes Act, or sometimes called the General Crimes Act. It doesn't involve civil jurisdiction. Of course, the cases that have already been out there for some period of time say otherwise. For example, Mustang Production versus Harrison, 1996. Okay. And in that case, they were trying to argue that somehow the footprint or definition of Indian country in the criminal context only applies in criminal cases. And of course, the 10th Circuit said, no, that's not true. The Supreme Court, U.S. Supreme Court in Dakota versus District Court, which was a disestablishment case from South Dakota, said very clearly it applies to civil jurisdiction as well. So the fact that the arguments that we continue to see sometimes that, well, McGirt is only applicable to, criminal matters, doesn't involve civil matters, doesn't involve tax, doesn't involve regulatory matters, is simply contrary to what the court decisions have been. Nonetheless, those arguments keep getting made, including change in position of the federal government with respect to the authority of the United States recognizing either the state of Oklahoma or the Creek Nation having authority to regulate in certain areas. And this is an example relating to coal. The Office of Surface Mining and Reclamation of the Department of Interior essentially told the state of Oklahoma that they are the only ones that can regulate coal mining within Indian country, and issued a letter saying essentially that in the Creek Nation, the Oklahoma state authorities don't have any jurisdiction to regulate coal mining because it's within Indian country. Similar decisions were made involving the Cherokee and Choctaw reservations. Notices were provided, and that resulted in the state of Oklahoma filing a lawsuit in federal court. It's still pending in front of Judge Fried, I believe, in the Western District, as to whether or not the state retains some authority of some sort, contrary to what the federal Department of Interior is saying. And that case is still pending. So we're waiting for a decision ultimately in that case. I don't think anything's happened yet. The last I looked, it's still before the court. Of course, this is the map of the original reservation areas in Oklahoma. All the tribes, 5 tribes in this area, and the Quapaws have had their boundaries recognized by state court decisions, Oklahoma Court of Criminal Appeals. Other boundary possibility recognitions continue to exist for other reservations, depending upon their allotment agreements and the federal statutes. with respect to how their allotment agreements were negotiated and all of the factors. Interestingly, some prior boundary disestablishment cases in Western Oklahoma and elsewhere relied upon a lot of the factors that McGirt has said are improper, such as comparisons of population or other matters. Tribal consent, whether or not there was an operating tribal court system at the time of the decision. Dakota versus District Court, essentially relied upon differences in population, the fact that there wasn't a tribal court operational, and coming to the conclusion that the state had jurisdiction. So the question is, do those factors that McGirt has essentially said are improper, are the federal courts and the state courts going to continue to apply those when they look at other reservation disestablishment cases, not just in Oklahoma, but even elsewhere? Okay, and most recently, the Osage District Court of Osage County made a determination that the Osage Reservation was disestablished. That is on appeal now. We circulated information about that about 2 weeks ago. We can probably upload that to the Dropbox, that decision, but that is being appealed. Okay, so the other factor besides the land, we look at who's an Indian. Of course, depending on which tribe it is, tribal membership varies from tribe to tribe. The two-part test that we talked about from the 10th Circuit and from the Rogers, or actually a case out of the 10th Circuit, relying upon Rogers, which was a US Supreme Court case, looks primarily at Indian blood. If somebody has Indian blood, and some government has said that they're entitled to recognition for special services as an Indian, and that can be from the federal government or from the tribal government. Generally, those are the factors that we look at in determining whether or not somebody qualifies to be an Indian. We continue to see people, politicians and others say, well, if you have an Indian card, you're an Indian, or if your Indian card doesn't have enough blood, maybe you're not an Indian. Again, a CDIB card is not proof that somebody is an Indian under federal law. You have to have some Indian blood, and you have to have a government, either the tribal government or the federal government, say, we recognize you as an Indian for a particular purpose. Again, most of the 5 tribes rely upon CDIB cards because there's no minimum blood quantum. Most of the other tribes in Oklahoma do have a minimum blood quantum. Some are descendancy, such as the Citizen Potawatomi, like the 5 tribes, but it depends from tribe to tribe. So when we have a crime that takes place, that's the first thing we have to look at is, do we have a certain degree of Indian blood? Doesn't matter how little. And is there a tribal government or the federal government recognizes somebody to be an Indian? Just a few days ago, 3 days ago, actually, Supreme Court looked at this issue. It was an appeal brought by the state of Oklahoma with respect to a couple of individuals, Mr. Watkins and Mr. Sam. And the question was whether or not they were Indians. And the issue which came up at the district court level, and I've got some language from that opinion, was whether or not, because they were not enrolled in the tribe at the time the crime was committed, were they an Indian or not? Okay, so in Watkins, and this is the Court of Criminal Appeals decision, they cited the district court had written findings, facts, and conclusions of law that this defendant had a CDIB 3/16 Choctaw. He was not an enrolled member of the tribe at the time of the offense. The court said he didn't possess a CDIB card, but I think later on they determined that he did have a CDIB card. And again, the dates on CDIB cards are nothing more than like a date on, I don't even know if there is a date on your voter ID card or your driver's license, I probably have at least 5 different CDIB cards, and the date on the card doesn't mean anything other than that's when it was issued. It doesn't mean that that's, when you had the Indian blood. Of course, you had the Indian blood the entire time, from the time that you were born. So that the date on that card really is irrelevant. Although we see a lot of law enforcement in some counties looking at that date on the card or the date on a tribal membership is somehow dispositive of when somebody's an Indian or not. So Mr. Watkins was convicted in May of 2018. He didn't enroll until October 9th of 2020. And so the district court said, well, you're not an Indian because you weren't a member of the Choctaw Nation. And until, because the crime took place beforehand, you're not an Indian. And said the district court said you fail to meet the standards set forth in the Rogers test. And then so Watkins had said that he had various factors to prove his recognition, that he had received some services from the federal government. I think there were services from the Indian Health Service. And these are the things that the Court of Criminal Appeals said that you have to consider: tribal enrollment, government recognition formally and informally through the receipt of assistance, enjoyment of the benefits of tribal affiliation, and social recognition. So ultimately, the Court of Criminal Appeals reversed that decision made by the district court in Mr. Watkins' case. That was the subject of the petition, the cert petition brought by the state of Oklahoma. And on October 11th, the U.S. Supreme Court denied cert, leaving that decision in place. Okay. So again, so we looked at the status of the person who's an Indian and who is not. Tribal jurisdiction has been expanded, and several speakers have mentioned that since 1978, which was kind of the most restrictive time of tribal jurisdiction. Tribes at that point in time only had jurisdiction over Indians and only over misdemeanors, no jurisdiction over non-Indians because the Oliphant case. Since that time, jurisdiction has been expanded. There's been recognition as a result of the Tribal Law and Order Act, the Duro Fix, VAWA, to expand jurisdiction over not only Indians, but now to include non-Indians, not over just misdemeanors, but now to include felonies. Under the Tribal Law and Order Act, a tribe can prosecute somebody for up to a penalty that would include up to 3 years. That can be stacked 3 times for up to 9 years. Under VAWA 2013 was the first time tribes could exercise jurisdiction over non-Indians. And that it was over 3 categories of crime: domestic violence, dating violence, and violence of a protection, violating a protection order. Now, because of VAWA 2022, VAWA 2013 has been expanded, and that's really the reason that we're doing this training today. And it's now been codified in 25 U.S. Code Section 1304, what that includes. The law was signed into effect on March 15th with an effective date of October 1st. There's no approval needed from DOJ or BIA. Interestingly, for those of you that haven't looked very closely at it, VAWA 2022 also, because there's technically no Indian country in Alaska other than tribal trust lands or allotments, with the exception of the Metlakatla Indian community. VAWA 2022 created a special jurisdiction in tribal village courts over lands that not only includes Indians, but includes non-Indians. And so then the question is, well, what lands are we talking about? The statute defined lands to be essentially village lands recognized by the United States Census Bureau, which is very interesting. doesn't create federal jurisdiction, doesn't create Indian country over the village Census Bureau defined lands, but creates tribal jurisdiction over those lands and creates village tribal jurisdiction within the village also over non-Indians. And there are 5, they haven't yet been designated, but there are going to be 5 villages that are going to be able to exercise this jurisdiction over non-Indians. It can be expanded up to 30 villages, and they're in the process right now, both Interior and Justice, in determining which of those villages will be able to exercise that jurisdiction. Now, some of you may remember under VAWA 2013, there were some limitations, basically some minimum contact type of limitations, which would have prevented the exercise of jurisdiction for essentially kind of a fleeting contact with Indian country. Those have been eliminated. So these things here about having sufficient ties to Indian lands no longer a part of VAWA 2022. So that restriction is no longer there. So what does VAWA 2022 now include? It includes recognition of a tribe's inherent criminal jurisdiction over non-Indians for the following types of crimes: child violence crimes, sexual violence crimes, stalking, sex trafficking, assaults of tribal justice personnel, and obstruction of justice. And again, the crime has to be part of the tribal code. It has to occur within the tribe's Indian country. The minimum ties requirement from VAWA 2013 have been removed. There is also a new requirement that the tribes have to provide notice to non-Indians of their federal habeas corpus rights under the Indian Civil Rights Act. So how that's going to be done, I'm interested to hear from Kara Bacon how the Choctaws might be providing notice of that right, and if that's going to be part of the court record, how is that going to actually be implemented on the ground? There was an old term called special domestic violence criminal jurisdiction that is no longer existent. Now, we refer to this jurisdiction that the tribe has over non-Indians as special tribal criminal jurisdiction, because it's not limited anymore to just domestic violences. So these are essentially a summary of the areas that tribes can now enact codes that are collectively referred to as the covered crimes under VAWA 2022 and VAWA 2013. There's also an expanded definition of what is considered to be domestic violence and dating violence. Some court decisions had limited or had a very narrow view of what domestic violence and dating violence authorized by VAWA that could be exercised through tribal court were. And so VAWA 2022 and codified here at 25 U.S. Code 1304 defines what domestic violence is. So a court won't be struggling with figuring out whether or not a crime is a domestic violence crime or not. Also, VAWA 2022 clarifies that for cases involving obstruction of justice or assaults against tribal justice personnel, a tribe has jurisdiction even if the victim is a non-Indian. So this is the very first time that a tribe has jurisdiction when it's committed by a non-Indian against a non-Indian. I don't think that that's really ever existed before. The other crimes that are part of VAWA 2022 have to involve an Indian victim when there's a non-Indian offender. We talked about the habeas corpus rights that have to be applicable. 1304 doesn't cover cases when both are non-Indians unless it's one of the categories of assault of the tribal justice personnel or obstruction of justice. This expanded jurisdiction also does not apply outside of Indian country. It only applies within Indian country. And the exercise of this jurisdiction it's up to the tribe. The tribe doesn't have to exercise this jurisdiction if they don't want to. If they don't want to pass statutes to exercise it, they don't have to. It doesn't change any existing federal or state jurisdiction either. A lot of the ICRA, Indian Civil Rights Act due process requirements come straight from the U.S. Constitution. They're all listed there in 25-1302A. A lot of the things that are familiar in federal or state courts. Also, TLOA requires that effective assistance of counsel is a requirement. So we're talking about defense attorneys, law-trained tribal judges, publicly available criminal laws, recorded proceedings in tribal court. Those are all requirements from TLOA. Also, VAWA requires the tribal court has to provide a right to a trial by an impartial jury, and non-Indians cannot be systematically excluded from tribal court juries. So tribal courts have to make sure that their jury selection process is up to date to include non-Indians. Okay, we talked about state jurisdiction in Indian country, the McBratney exception that was discussed by Professor Helton. Of course, what resulted because of the perception that a state didn't have jurisdiction in Indian country, that was everyone's perception. So that's why Public Law 280 was passed in 1953. Interestingly, if you look at the statement that President Eisenhower issued at the time that he signed Public Law 280 into law, he had an objection to it. And his objection was the fact that there was no provision for getting tribal approval before the state was given jurisdiction in Indian country. This was in 1953. President Eisenhower said, I recommend at the earliest possible time in the next session of Congress, the act be amended to require consultation with the tribes before the state gets jurisdiction over Indian country. Of course, that didn't happen until 1968. 1968, Congress acted and said, okay, so it's not just a tribal resolution from the executive. It's not a tribal council resolution to allow for the exercise of state jurisdiction over Indian country for a particular tribe. This statute requires that there be a special election conducted by the Secretary of Interior that shall be applicable in Indian country where the enrolled Indians within the affected area of Indian country accept such jurisdiction. So there has to be a vote. There has to be a vote of everybody within the affected area of Indian country. Question is that just people from that tribe, or does that include all enrolled Indians? I don't know if that's ever been answered, but certainly if you read it, it says enrolled Indians. So, you know, if the Chickasaw Nation wanted to give jurisdiction to the state of Oklahoma for certain types of crimes over Indians, then would that just be Chickasaw members, or would be any Indians living within the boundaries of the Chickasaw Nation? Of course, everybody thought until Castro-Huerta that jurisdiction, non-Indian versus Indian crimes was only federal. That was the ruling of every Supreme Court from any state that's considered the issue. That was the position of the federal government. That was the position of the United States Department of Justice, that non-Indian versus Indian crime was exclusively federal. And of course, June 29th, 2022, the Supreme Court held otherwise, as we've discussed, and said, despite the fact that there's been no enactment under Public Law 280 or any other act, the state somehow had this jurisdiction from day one. We've already had a pretty lengthy discussion about, you know, the rationale or impetus behind that decision, and called into question the territorial aspect of Worcester versus Georgia. So now we have concurrent federal and state jurisdiction everywhere in Indian country, not just Oklahoma, throughout the nation. So we look at the implementation of this. What does this actually mean? Okay, so this was a memorandum that was issued by the Attorney General for the state of Oklahoma. And it says basically that this was directed to law enforcement, and said, if you look there in the highlighted blue section, well, now that the state has jurisdiction under Castro-Huerta, what are you to do? Well, it says that law enforcement officers should give the state district attorneys the option to prosecute first before anything's referred to federal government for prosecution. So the question is, how are federal prosecutors or tribal prosecutors going to even know that there's a crime by a non-Indian against an Indian? Do they report to us? Well, according to this memo, it sounds like, they're just to report to the district attorneys and that's it. How am I supposed to know as a federal prosecutor? How is Kara Bacon supposed to know as a tribal prosecutor that somebody got stopped on the road or that there was an assault by a non-Indian against an Indian if nobody even lets us know? How are we supposed to proceed? How are we supposed to know that whoever is investigating this crime is covering the elements that we need to have a federal prosecution? Because I can assure you, I've gotten a lot of cases in the U.S. Attorney's Office. The definitions, the questions that need to be asked of victims, for example, in the sexual assault area, are different when it's a federal prosecution. We have to know what kind of fear the victim was in. There's two kinds of fear under federal law, and I have to know if it's fear of serious bodily injury, kidnapping, or death, or if it's other fear. If those questions are never asked during the investigation, how are we supposed to have the evidence or the elements to prove our case federally? And if we're not included at the very beginning, that could cause, major problems, having to go reinvestigate, re-interview witnesses. And in the child sexual abuse context, that's the last thing that you want to do, is to have to re-interview child victims. And again, the other thing about this memo is there's nothing about notification of tribal prosecutors, no mention at all of that. Notwithstanding the fact that VAWA 2022 had been signed into law in March of 2022. Another issue that's coming up is what's called the Pettit policy. Now, some of you may have heard me refer to that, the Pettit policy, and it's kind of a complicated series of things, but summarizing it, essentially, if somebody has already been prosecuted at the state court level, can we just go into federal court? Can I, as a federal prosecutor, go to a federal judge and get a complaint? Can I present a case to the grand jury if there's already been a prosecution and maybe an acquittal at the state level? Or they've already been charged and sentenced? Can I do that? The answer is no, I cannot. Can the U.S. attorney, above myself as an assistant U.S. attorney, authorize filing of charges against somebody who's already been charged and prosecuted in state court? The answer is no. We cannot do that. Why? It's because the Department of Justice has this policy that says we cannot do that at the local level. We have to get approval from Washington, and that's not an automatic approval. Yes, it's not a violation of due process for the federal government to come back in after the state government has prosecuted somebody, but it's not an automatic thing either. It's not something that we can even do at the local level. And so what is it that we have to look at? The policy, and this is public policy, it's reported in cases, it's nothing internal to the Department of Justice, but it's basically a policy that was developed to prevent or closely evaluate whether or not somebody should be prosecuted a second time. And there are various compelling interests that have to be shown to do that. And like I said, the approval is not at the local level. The approval is at the level of, an assistant attorney general. What do we have to show? We have to show that there's a substantial federal interest. We have to show that the prior prosecution left that substantial federal interest unvindicated. We can show, because there was incompetence or corruption or intimidation or undue influence, or there was jury nullification that disregarded the evidence, or there was the unavailability of significant evidence at the time, or there was a failure in the state to be able to prove an element that wasn't contemplated by the federal offense. So these are some substantial requirements that are made applicable before we can even get a federal prosecution of a non-Indian versus Indian crime after the state has already prosecuted somebody. And of course, there has to be a federal offense involved. So that's a substantial impediment. So it's not an automatic thing for the federal government to be able to come in and prosecute after there's been a state prosecution. Okay, we talked a little bit. This is another issue that's popped up. I'm going to cover it quickly. We're running out of time. Some of you have heard about the Hooper case. The Hooper case basically came out of the city of Tulsa municipal court that looked at the Curtis Act and said, well, the Curtis Act gave municipalities organized under federal law, under the Curtis Act, back before there was a state of Oklahoma, certain authority, and essentially focused primarily on treatment of racially treating different people similarly. The municipal court ultimately held that, and this is the conclusion of the court, that Section 14 of the Curtis Act gave the city of Tulsa some substantial kind of super jurisdiction, because the Curtis Act says that it applies to all persons regardless of race, and essentially found that the city of Tulsa has more jurisdiction than the state of Oklahoma. Notwithstanding the fact that I think, and I would have to confirm this because I'm not exactly certain, but I know that the Cherokee Nation did a very good brief, and we'll provide that if I can locate it in the Dropbox. But I think the city of Tulsa ultimately was organized later under Oklahoma law. So somehow does it retain this pre-statehood status, even though later the city of Tulsa was formed under Oklahoma law? In any event, this decision said essentially that somehow the city of Tulsa has more jurisdiction than the state of Oklahoma. Well, that ended up in federal court. And here's an excerpt from a brief that was filed in opposition to that position in federal court that basically said, this was the position saying that the Curtis Act really didn't, that wasn't really the purpose of the Curtis Act, and the decision made by the municipal court in Tulsa was incorrect. Well, that ended up in the Northern District, and there was a visiting judge from New Mexico, I believe, who considered that, the briefs and the argument, and upheld this Curtis Act argument, saying that the city of Tulsa somehow continues to have this expanded jurisdiction under the provisions of the Curtis Act, and therefore has inherent authority over all people, including Indians. So where does it stand right now? Well, that's been appealed to the 10th Circuit. The appeal was filed May 2nd, so briefing's underway. So that's another thing that's going on. I'm going to go ahead and wrap up now because I think we're to the conclusion of the time. The majority, I might go forward just a little bit. The majority of the other slides that are included here are basically what statutes we rely upon in prosecuting crimes when they're victim crimes in Indian country, or when they're crimes of general applicability. Of course, most of our jurisdiction in victim crimes comes from the Major Crimes Act or the General Crimes Act, and that sets up the matrix when we have an Indian or a non-Indian, or a non-Indian versus an Indian. That came about as a result of the Pro-Dog decision. We got the Major Crimes Act that basically lists out certain crimes, a list of crimes that apply when committed by an Indian against a non-Indian or any other person. or an Indian. We sometimes incorporate state law. That's called assimilation. And then the General Crimes Act, which was at issue in the Castro-Huerta decision, gives the federal government jurisdiction when there's a non-Indian versus Indian or Indian versus a non-Indian crime. And that basically includes the entire federal code. It's
Get
not
something
limited
done here.
to the main Crimes Act crimes that are more narrow. Okay, somebody's off of mute. If you could mute your phone,
Hello.
if you could mute yourself, that would be great.
Catherine.
I'm not sure who that is. I don't have the ability to see my entire screen, otherwise I would mute them. Okay, I think they took care of it. All right, let's see here. I'm going to go ahead and conclude. The remainder of the slides are included in your materials. I think they're pretty self-explanatory. I've almost exhausted my time here, but let's go ahead and stop the slideshow and see if we have any questions. We can go over a little bit. I don't want to cut too much into Kara's time, but we can probably go for at least maybe 5 or 10 minutes. Any questions? The next code word is creeping bear, creeping bear. And if you haven't figured it out yet or not, these are Indian artists from Oklahoma. So we had Haney, Blue Eagle, and now Creeping Bear. And we'll have one more. Let's see, any questions? Okay, somebody said an Indian can run red lights, cause accidents, and yet get away with it. Absolutely not. That's not correct. Somebody can be charged in tribal court. They can also be charged in federal court. The process to do that is they can be charged either by issuance of a Central Violation Bureau citation in federal court, or they can be charged in tribal court. And many state and locals have gotten authority from the tribes or gotten authority by having a special law enforcement commission. And some of the later slides describe that process. So no, we don't want anybody getting away with traffic violations. And again, the city of Tulsa can do nothing. Well, that's correct, because the city of Tulsa, the state court, does not have jurisdiction over Indians within Indian country. That's what Congress has set up, and that's what the law provides. Does that mean they're going to get away with it? Absolutely not. They can be prosecuted at state or federal court. All right. Any other questions? And if you have some other questions that we don't have time to get to, please put them in the chat, and then I will see if we can try to answer them in the chat room. Okay. All right, I see Kara has got her screen going there. Again, the next word is creeping bear. Kara, I'm going to make you a co-host so you can show your slides here. And also in the materials, there's a jurisdictional chart. We previously circulated it. It's located on the U.S. Attorney's website for the Western District of Oklahoma. It summarizes basically all of the new amendments that we discussed having to do with VAWA and having to do with the Castro-Huerta expanded jurisdiction by the state. Okay, I'm going to go ahead and introduce our next speaker, Kara Bacon. Kara is a member of the Choctaw Nation. She got a Bachelor of Arts degree from Southeastern Oklahoma State University. She got her Juris Doctor's degree from the University of Oklahoma College of Law. She had an emphasis in Native American law. She worked as a district attorney for 6 years, primarily in Grady and Caddo County. She also was appointed and served another 4 years as the first assistant district attorney for District 6. District 6 includes Grady, Stevens, Caddo, and Jefferson counties. She handled all types of cases, including juvenile delinquent cases, deprived, felony, and misdemeanor cases, and violent crimes and sex crimes as well. In April of 2019, she joined the Choctaw Nation to serve as one of their tribal prosecutors. As the tribal prosecutor, she supervises division chiefs, assistant prosecutors, caseloads, and prosecutes sex crimes in Choctaw Nation tribal court. Since McGirt and the Sizemore decisions, which made or recognized the boundaries of the Choctaw Nation, she has overseen the expansion of the tribal prosecutor's office and has developed practices and implemented procedures to prepare the nation's courts for handling cases as a result of the McGirt decision. And talking about percentages and statistics as a result of McGirt, and under her leadership, the volume of cases prosecuted has increased. Now, I think this is the largest percent I've ever seen, I think, in connection with these cases. Increased by 2,753%. That's pretty impressive. So I will turn it over to Kara, and you can go ahead and unmute. And we look forward to hearing from you from the perspective of a tribal prosecutor.
Arvo, are you able to hear me now?
Yes, that's 100 times better. Thank you.
Okay, there we go. Let me
Oh.
start over then.
Okay, awesome. Now we can hear you.
Okay. All right, so the Choctaw Nation has implemented VAWA 2013, and then we recently enacted legislation to go forward and amend our code so we could exercise jurisdiction under VAWA 2022. So just a history of VAWA, and the original Violence Against Women Act was passed in '94. It was the first legislation that acknowledged domestic violence and sexual assault as crimes and provided federal resources to encourage communities to combat violence against women. This is a grant that's administered by the Department of Justice and the Department of Human Services. It is up for renewal every 5 years. Part of the goal of the Violence Against Women was to enhance investigation and prosecution of sex offenses and to provide a number of grant programs to address the issue of violence against women from a variety of angles, including law enforcement, public, private entities, service providers, and victims of crime. So for a long time, state and local governments have been able to utilize this funding, and other DV resource centers have been able to utilize this funding for a number of reasons. I think it can vary from anywhere from BIP programs or assessments to law enforcement officers that specifically investigate domestic violence, prosecutors, victim witness personnel. However, post 1978 and post Oliphant, for a number of reasons, the Congress had looked to expand VAWA to address some of the issues that we were seeing in Indian country, specifically when you look at non-native on native crime. And I think they cite that it's due to a number of reasons. One of those, I believe, is the lack of prosecution at a federal level, whether that's due to resources or due to the type of crime, or the lack of investigation and the lack of being able to submit that to federal authorities. We enacted VAWA actually in 2015. We were one of the second round of tribes. We weren't one of the pilot programs. And so when we enacted VAWA, there were a number of things that I think we looked at and that I think other tribes need to look at when you're talking about consideration. One, in this slide, you will note that the majority of Indian country in the Choctaw Nation is down in the southeastern part of the state. It's very rural, and our headquarters and our main courthouses in Durant, our original courthouse is in Tallahena, which is in the middle of the reservation. But when you're talking about coming from the tip top of the reservation down to where our largest courthouse is, it's about 3.5 hours. There are 4 DA districts within our reservation boundaries, and all of the Choctaw Nation is encompassed in the Eastern District, the U.S. Eastern District. But from a logistical perspective, you have to consider the resources, not only the prosecution resources when you're looking at implementing VAWA, but also the resources of your police departments that are going to be working to investigate those crimes. And then what services do you have to offer the individuals, both the victims of crime and the offenders? The other, cost consideration is definitely going to be with incarceration cost. I believe there are some part of 13 counties within the reservation. We really utilize about 9 of those county jails as pre-adjudicatory holding and then post-incarceration. We did not utilize the VOP program under VAWA 2013. And I will talk about that a little later on in the presentation. But for purposes of this presentation, it was because, one, we didn't really prosecute a whole lot, even though we had enacted VAWA. Prior to McGirt, I found 1 domestic violence prosecution and no special domestic violence prosecutions until McGirt, until the year before McGirt. And so we really just utilized the county jails within the reservation boundaries. But that's definitely a cost. I know that for us, at least, prior to McGirt, our incarceration costs ranged at around $7,000 to $8,000 a month. Now we're looking at anywhere from $70,000 to $80,000 a month on incarceration cost. The other consideration is, although there's a lot of grant opportunities when you're looking at implementing VAWA, at least from a political consideration, the Choctaw Nation, if we take on grant opportunities, the tribe wants to make sure that they can support those positions after the grant funding periods have ended. We also noticed that with VAWA 2013, after McGirt passed, we saw a lot more appeals in the realm of VAWA. And I think that is partly due to having to exhaust tribal remedies before you seek habeas. And so we were seeing a lot of appeals from VAWA cases that through the VAWA cases on questions of whether something qualified as domestic violence. When we looked at implementing VAWA, we also implemented TLOA at the same time. And TLOA is the Tribal Law and Order Act that gives tribes the expanded sentencing power for up to 3 years per count or up to 9 years per case. However, when you look at implementing TLOA, although I do believe it gives VAWA teeth and that it allows you some greater sentencing power, and especially when you're talking about violence or domestic violence, intimate partner violence, or sexual violence, these are the type of cases that typically you will see more incarceration. Specifically at the Choctaw Nation, we noticed that we have more incarceration costs related to VAWA-related cases or sexual violence cases. So with the expansion of VAWA, you can anticipate that those post-incarceration costs will go up. I have here that our pre-McGirt filing was 1 special domestic violence case, and then the year after that we filed 84, just to give you an idea of how much our non-Indian offender incarceration and filings were. Prior to McGirt, we also looked at a review of all the codes. And when we looked at VAWA and TLOA rights, we had already enacted basically ICRA provisions under our Constitution and then codified those rights. The one thing to keep in mind, though, is when you look at enacting TLOA, what we saw was that the cost that were really associated with the rights are going to be when you're talking about providing a right to counsel for those who cannot afford it, and when you're looking at the record keeping responsibilities that are under TLOA. So under TLOA, you're required to keep a record of all proceedings. It does not have to be a court reporter record. However, our Constitution requires that in criminal cases. So it's something to be mindful of. Know your own tribe's provisions when you go to implement these things, and make sure you understand what your own tribe requires along with what is required under TLOA and VAWA. One of the other big amendments that we went through, when we initially enacted these, we had two separate panels, jury panels, and that is because under VAWA, the defendant is entitled to a fair cross-representation of their peers, so you cannot exclude non-natives from the jury pool. What we noticed was when we did our jury pools, it was really hard to determine if we would definitely have a domestic violence case going. And so what we did was we amended the code to allow for two separate or to merge our two pools into one. So we no longer have two jury pools. Now we just have one jury pool. Let me see if I can pull up the so currently our juror code, when we amended it, and I think it was 2019, our juror code allows more than 20 days for the judge to determine how many jurors are needed in each case. We have a 6-man jury in the Choctaw Nation, so typically we will select about 100 for each pool. We utilize software through Tyler Technology. It is similar to what I think most of the counties in the state utilize to select our jurors to make sure they are random. That selection process goes through our Choctaw Nation membership records, our human resource records, and when you look at the Choctaw Nation and Choctaw Nation, not just our government, but our commerce and enterprise, we have more than 12,000 employees to choose from across the nation. So that gives us a pretty large jury pool of potential non-natives. We also take tribal tag records of non-members. So if there is a spouse in the home who is a non-member, we utilize that to select jurors. And we also use our Biskinik record, which is our newspaper for non-member recipients. So we pull from those. It is completely random. And one of the unique things about the Choctaw Code prior to McGirt was that there really wasn't teeth. It wasn't a required duty. Now it is a required duty that carries penalties if you do not show up for jury duty. But we also incentivize jurors by paying $100 a day in jury fees and paying mileage. There are certain items in our juror code or certain positions that will disqualify you if you are an elected or appointed official. Tribal council, nor chief or assistant chief are eligible for service. Licensed attorneys or peacemakers are not eligible for service, nor are judges, court clerks, bailiffs, or any of those employees that work for the court or the appellate or constitutional court. We also provide, the juror code provides excuses for those over 70, private or public school teachers, practicing physicians, optometrists, dentists, or veterinarians, or jurors who have served within the past 2 years. Choctaw Nation's code is unique in that it does not require the jury to determine punishment. Typically, our jury trials, even our felony jury trials, don't last over a day just because you're not dealing with 12 jurors, you're dealing with 10, and they're not having to determine punishment. So we also made updates to our criminal code. One of the things when we, prior to McGirt, after we had enacted VAWA, we saw that many of our provisions were a little dated in regard to domestic violence. So one of the things that we noticed in police reports were we had a lot of cases that involved domestic violence by strangulation. One of the things we knew about strangulation was that within seconds, it can cause a loss of consciousness, and within minutes, someone can lose their life. Also, we knew that when statistics show that when there is strangulation in a domestic violence relationship, that victim is 750 times more likely to be killed by their offender. So we made domestic violence by strangulation a felony under our code. We also added a provision for a prior pattern of domestic violence, which was 2 or more instances of domestic violence within a 6-month period. That can include the current instance of domestic violence, but must have an independent third party or other direct evidence independent of the testimony of the victim for the other incident of domestic violence. And then we added a second and subsequent domestic violence provision. So if an offender had a conviction, a misdemeanor conviction, and then later committed another crime of domestic violence, that would enhance that new domestic violence case to a felony case. In those instances, we do file what we call a page 2. We file by information at the Choctaw Nation. So that second page alleges the prior offense, where it occurred, what the sentence was if they were represented by an attorney, and that would be proved up in a bifurcated trial. One of the other things that we did after enacting VAWA, the 2013 and TLOA, was we went ahead and established a public defender's office. It was very important to the leadership at the Choctaw Nation that we had a fair process. We had newly established a in-house prosecutor's office. Tribal Council wanted to assure that people's rights were protected and that they invested in ensuring that there was a fair process. So I think we are one of the only tribes in Oklahoma that have an established public defender's office. Currently, we have 1 head public defender, and there are 5 assistant or public defenders in that office. I will say, due to the rural area or the rural nature of the reservation, the Choctaw Nation, they take on about 95% of the cases, even though it is based on, or it's income based. It's very rural, there's a lot of poverty, and so they do handle about 95% of the cases that come through the court system. We applied for a grant post VAWA 2013 to be able to administer our own BIP program, one that has a cultural aspect. They're in the process of determining how that assessment is going to look. And for those of you that don't know, BIP would be the Batterers Intervention Program. And so that is something that we have started. It's grant funded, and we have a position that will be dedicated only to doing those assessments and providing a course on batterers intervention for all of our domestic violence offenders. We also have, since the implementation of VAWA, started internal MDTs or multidisciplinary teams to address sexual assault and domestic violence. It's kind of been a opportunity for us prosecutors to get with law enforcement and to get with our family violence department that offers services to victims, to develop protocols, provide trainings, and really just have an open line of communication as to what officers are seeing in the field, what family violence workers are dealing with in the field and through victims, and give us a better idea of how the system's working overall. So some of the lessons that we learned through VAWA 2013 was that we had to establish an evidence-based prosecution for us to have success in implementing VAWA. And what I mean by that is we were seeing a lot of cases where our victims were either uncooperative or would recant or would not want to cooperate. And so we started working with our law enforcement partners and determining what evidence we would need or what evidence they could provide that would allow us to prosecute regardless of whether the victim was cooperative or involved in the case. We also established some protocols in our office on how we would treat these cases, standardized recommendations, standardized bonds. Our criminal justice department, which administers all of the in custody incarceration, they keep up with who's in jail and provide transportation, but they also have our probation department. They ordered a lot of ankle monitors for stalking, VPO, and domestic violence cases. And we can't get enough of them because it allows us to keep tabs on victims and help victims stay safe once they have made bond or are released from jail and on probation. We did a lot of training and education on domestic violence, and we worked in part with our domestic violence program. Choctaw Nation's domestic violence program can provide emergency funding for victims. So if law enforcement goes on to the scene and they meet protocol, they can provide vouchers for emergency assistance or to put someone up in a hotel room for a night. But then beyond that, they also provide transitional services, education for the victim, first month's rent, assistance with getting electric turned on. And so those are some of the resources that the Family Violence Department can provide for victims of domestic violence. We also set up protocols for we got 2 victim witness coordinators in our office and established some protocols for them to make contact with the victim within 2 days of filing of charges, notify the victim of the charge, of what the bond is, what the bond conditions are, and then connect them with the attorney so they can develop a relationship and try to stay in contact with that victim throughout the pendency of the case. So I talked about the meeting protocol to involve the Family Violence Department. Part of that protocol is a list of questions. It's called a lethality assessment. So a case study I brought today, and this was the one special domestic violence case that went to jury trial where we had a uncooperative witness in this case. This case involved a single mom with 3 kids and a 17-year-old child. One of the older children here fighting in the living room. It's in the middle of the night. They call 911 for help. The officers that arrived were cross-commissioned with the Choctaw Nation, and they were familiar with the house. They had been to the home on several occasions. The police officers all had body cam and dash cam. They made contact with the children and with the mom and with the defendant. They went over the lethality assessment, which is what I have attached here for those of y'all who do not understand what that tool is. And it's basically to help law enforcement understand how volatile the situation is and connect them to services. It also helps from a prosecution perspective, give us an idea of what type of situation we're working with, if this is something that's been going on for a while, if this is a person that might need a higher bond and more conditions of bond. In this case, she refused immediately after law enforcement arrived. She did have injury to her face and the defendant was arrested. Soon after it came to the Choctaw Nation, the defendant had multiple prior protective orders and misdemeanor domestic violence charges. All of those had been dismissed due to an uncooperative victim. Because there were children in the home at the time this incident occurred, the Choctaw Nation would not dismiss the case without some kind of treatment as a condition of probation. This case went to jury trial. We did utilize, and that's one of the other things we implemented when we started VAWA 2013, was we implemented using a domestic violence expert, someone that can explain to the jury the cycle of violence and the reasons a victim of domestic abuse might be uncooperative or might act contrary to what is in their best interest. In this case, the victim did testify, but she denied any domestic violence. Her son also testified. We had the local law enforcement agency set as a case agent in the case. It was beneficial for us to give them an idea of how tribal courts looked and what our process was. In this case, the jury did find the defendant guilty, and I think it was due to the amount of evidence that law enforcement were able to obtain on the front end. However, these types of cases, I think, will continue to remain difficult for prosecutors when you have a victim who is uncooperative or unwilling to assist in the prosecution. So what we learned was that we were going to see an increase in incarceration costs from 2013. We were going to continue to see an increase in our caseloads, and that we needed to ensure that outside agencies understood our extradition process. So our extradition process requires anyone that is picked up on a warrant outside of the Choctaw Nation reservation boundaries to waive extradition before we can go get them. And that's something that's kind of hard for outside or for state and local agencies to understand. They don't understand why someone's in Oklahoma that the Choctaw Nation will not come and get them without a waiver of extradition. We also developed a warrant and initial appearance procedure, essentially because we were dealing with an increase or uptick in VAWA, and we were seeing an uptick in cases post-McGirt. We had a backlog of warrant requests, either FBI warrant requests or warrant requests from agencies all across the reservation. And so we have, if it's a domestic violence case, we've asked officers to note that, because we give those cases priority. If they were unable to arrest within that time frame and have to seek a warrant, then we ask that the officers let our prosecutors know, so that we may screen those quickly to get those cases charged and get those warrants out. But one of the difficulties when we implemented VAWA 2013 and just in expanded jurisdiction in general is that
I'd like to be addressing the heinous attack. But this election now Congress has certified the results. I don't want to say the elections, I just want
Just say you're a big fat loser.
My only goal was to.
I'm sorry, I can't. Hello?
I would like to begin by addressing the heinous attack.
I think someone's mic's on. So one of the issues that we came across was that for arraignments, we needed our statutes require that the defendant be seen by the judge within 48 hours of arrest. And so we had to get with our county jails and implement a system where we have video, two-way video arraignments every day, which doesn't sound difficult until you're trying to coordinate that across 13 counties. So we've been able to work with many of the county jails across the reservation, and our criminal justice department will quickly move people into other jails who can ensure that we follow that protocol of getting people before a judge within 48 hours. We wouldn't have been able to do that as easy and as seamlessly if we didn't have the video technology to coordinate that effort. So in preparation for VAWA 2022, we went from a relation-based crime to or crime-based instead of relationship-based. So when we looked at the assault of tribal justice personnel, really we have the codes in place already to be able to utilize this. It's any violation. We added a specific provision, but essentially any violation of the criminal law of the Indian tribe that has jurisdiction over Indian country where the violation occurs, if they use or attempt to use force of a person in performance of their duties. And that's very broad under this VAWA 2022. So we did add assault of tribal justice personnel to our code. We had not had a provision that was broad enough to encompass all of that. In respect to child violence, and Stacy touched on this earlier, we had a pretty broad definition of child violence or child abuse, and it encompasses neglect. It can encompass sexual violence. So our definition of child violence is pretty broad under our code. We didn't have to do much to child violence, dating violence, or domestic violence. Our obstruction of justice was unique under our code. We did have to change that. Our obstruction of justice was basically interfering with the duties of an appointed or elected official in the Choctaw Nation. And so that does not encompass police officers. So we utilized the language given by the federal government and amended our obstruction of justice code. Our sexual violence codes were broad, and our sex trafficking was also tailored after the federal government. And so we didn't have to make any changes to our sexual violence or our sex trafficking or our stalking or VPO. But one of the things that we did have to do was we had to make sure that we were not only advising defendants of their rights, but we were making sure they had a notice of all those rights. So the way we decided to do that was we incorporated the rights under TLOA and VAWA, and we created a notice form that is read at arraignment to all defendants who are being arraigned. The judge signs this, and I'm going to see if I can click on this and show you a copy. Okay. So this notice of rights is what the judge goes over. Oh, taking a little bit of time to load. Sorry. So they go over the nature of the charges, and basically it's part of the arraignment. The judge fills this out in every case that is filed in the Choctaw Nation. It goes over their right to appeal, their right to a jury, and then it goes over their right to seek habeas. So this includes all of the required rights under VAWA and TLOA. It is something we file in every case, even those that are non-VAWA cases. Just as a general rule, the court decided it would be easier to ensure that everybody was read this right instead of trying to determine which ones, which VAWA defendants were read this. So that is how we handled it at the Choctaw Nation. The other thing we did was wanted to make sure that we were tracking our cost for the reimbursement provision under VAWA 22. I think that's going to be a little more limited than we would have liked. But each department that deals with a VAWA case is tracking that. So in our systems, we enter membership or non-native VAWA, and that is how we track all the hours and costs associated with those individuals. We also had to implement some practices in preparation for the use of the BOP travel prison program. So under VAWA 22, it allowed again for tribes to utilize the Bureau of Prisons tribal prison program. And I think it struck the language that made it a pilot program and had no sunset date. So it is still, it's my understanding that it's still limited to 100 tribal inmates at any given time. However, since it is permanent now, we are hoping that maybe we can work to develop an increase in that. I was told that under the 2013 BOP program, I believe only 6 inmates ever went through that program. And it could be because of the type of material that is required by the BOP. So essentially, for the tribe to participate, they have to certify that a sentence has been issued by a tribal court. The sentence must be a major crime. So I don't think all of your VAWA 2020 crimes are going to qualify. Also, the required information that you have to send to them is quite lengthy. It is essentially the type of information that would be contained in a pre-sentence investigation report. So as a result of this, the Choctaw Nation on all of our cases, all of our VAWA cases that have major crimes, we have required a PSI be ordered on all of those cases. That PSI is conducted by our probation department. And essentially, they look at tribal affiliation. The Bureau of Prisons wants to know about gang affiliation, about prior arrest, detainers, pending charges, outstanding warrants. They want to know about their family and personal data, their mental and emotional health, their history of substance abuse, their educational history, employment history, and physical condition. They also want to know about the victim's information, and they are supposed to let the tribes know within 30 days of receipt of all of the information they had requested. So we started a judgment and sentence protocol where the prosecutor's office will issue judgment and sentences because of the quick turnaround time and the limit of 100 beds. We have started doing those on all of these cases. As soon as the judge orders the sentence, the tribal prosecutor's office prepares the judgment and sentence for the judge to sign off and the court clerk to issue out. And then we start the referral process to BOP. We make sure before the defendant is sentenced that there is a PSI, and that has to be shared with the Bureau of Prisons as well. This should alleviate some of the tribe's cost under implementing VAWA 22. I think it is at least going to alleviate some of that for more of the serious crimes, the sex crimes, or the crimes against children. But we shall see. So these are the limitations, the custody conditions, and the cap on inmates, and that is from all tribes nationwide, 100 tribal offenders at any time. So cooperation with state and local governments. Since I have been at the Choctaw Nation, it seems like there has been a sense of a different sense of cooperation here. Tribal police and local agencies have been cross-deputized for some time, although we have increased those since McGirt. Essentially, we have always worked pretty well with state and local governments. The cross-deputization agreements allow those state officers to enforce VAWA. It's not, can they make arrests? It's where do they take those arrests? I think the jail agreements have been vital in allowing us to exercise TLOA and VAWA. But there is still, and I think Stacy brought this up, this question about what about these charges, these child abuse, these crimes of violence that could be considered major crimes, but the tribe has an interest. At least here, we have talked to some of our local DAs about, this question. And at this time, they are looking to defer to the tribe because the tribe has resources that they can offer the victim. And I think you're right, when you talk about Castro-Huerta and you talk about the decision, it changes the analysis when you see that the tribe does have a vested interest in not only protecting victims of violence, but in being able to offer the resources they might need as they go through that prosecution process. And so we have been lucky enough here at least to be able to sit down at the table with our district attorneys within the reservation and talk through these issues. We are in the process of rolling out at least a VAWA process or protocol for outside law enforcement. We're working in cooperation with the district attorneys so that they will know who to take those to. If both parties can prosecute, I think that question's still up in the air, but at least from their perspective, it doesn't make much sense for them to prosecute a case that the Choctaw Nation is prosecuting. Now, on those cases where it is a child victim and both the feds, potentially the state and the Choctaw Nation under VAWA would have jurisdiction, we're boots on the ground. We're trying to make a decision about what is in the best interest for this case, for this family. And so with the 9-year limit, depending on the type of crime, that may be a case that we would like the feds to step in and prosecute. And I think those, at least discussions, are going to continue. I think the questions from law enforcement are going to continue. And when I saw the letter that Arvo went over in his presentation, I think that just adds to the confusion for your officers who are on the ground and just trying to make decisions and handle cases as they always have. I think that leaves them confused and really kind of left out of the conversation. So from our perspective, VAWA 2022 is going to kind of be seamless here. There were only a few provisions we needed to change because we had already taken all of the steps to implement VAWA 2013. And I think the biggest part of implementing either of these are ensuring you have the constitutional provisions, you have the support, And you have the ability to exercise TLOA at the same time, and you have those the funding available to be able to do that in an effective way. I'm a little bit early, Arvo, so if you want to open it up for questions, I know it's Friday and I wouldn't be upset by getting done a little earlier than 5 o'clock.
That sounds great. Couple things. We do have a little bit of time. I did kind of want to summarize today, and I really appreciate that information, Kara. We've had some good presentations, you know, on the doctrinal aspect from Professor Halton and the implications that Stacy Leeds went over, and Kara, everything that you're doing at the Choctaw Nation to kind of make you know, these abstract concepts come to life. That's probably one of the biggest challenges, is trying to take these concepts and put it into you know, real time and real application to tribal members and non-Indians alike. I did want to go, since we have a little bit of time, real quickly over the jurisdiction chart, because I think everything that I went over and what you added to helps in terms of trying to make that clear. Let me see if I can expand this a little bit. So this is included in the Dropbox, and this is the updated, hot off the press jurisdictional chart that we have sent out. And actually, this is being utilized nationwide now. Initially, it was just something that we've done locally, but now it's nationwide. Just to make sure that you kind of understand it. So this applies within Indian country, and this summarizes basically everything that we had said throughout this training. We've got definitions of Indian country, formal and informal reservations, including rights-of-way roads, and you can provide this to whoever. You know, we send this out to the highway patrol, to a lot of DA's offices, to state and locals. This applies, there's no congressional granted jurisdiction, and we included state and municipal government to kind of indicate that, you know, this argument that the city of Tulsa has adopted. We'll see where that goes. I have serious doubts about its viability once it gets up to a higher federal court level. Anyway, so when the way you go through this chart, one page is Indian offender, the other page is non-Indian offender. Okay, so when we have a victim crime, offenses against a person or a person's property. Now, we've had some confusion out there, like, you know, is the tribe a victim? Well, not for the purposes under federal law of 1153 or 1152. A tribe is not a person. A tribe is a government. So you cannot, you know, if somebody goes into the casino and vandalizes property or smashes a machine, which happens quite frequently, actually, can we charge them under the Major Crimes Act or 1152? The answer would be it's not a victim crime. So you cannot count a tribe as a victim. We have that come up all the time. Definition of who's an Indian, we went over that. Recognized as an Indian by a federally recognized tribe or the federal government and possessing some degree of Indian blood. That can even be beyond that if you apply the Rogers test. Oh, so if it's Indian versus Indian, we got the Major Crimes Act crimes that are all listed here. We don't have a federal definition of incest, felony child abuse, or burglary, so we borrow state law. That's called assimilation. And then, of course, Indian versus Indian, the tribe can prosecute those if it's in the tribal code or if it's a CFR code, or the CFR code. If it's an Indian offender versus a non-Indian, we can charge Major Crimes Act crimes. But if we also can charge, and I've changed the statute, I've changed this reference here to previously used to say federal enclaves, and there's some language in Castro-Huerta that says Indian country is not a federal enclave, so that's why I changed it to federal territorial crimes, where it's the territory of the federal government. And again, unless the tribe has punished the Indian defendant, And this is authority under the General Crimes Act, the Indian Country Crimes Act, to get, full application of the federal code, not just the major crimes. And then we can also assimilate state laws. And then, of course, any crimes remaining in the tribal code or the CFR code. Now, there were some comments in the chat. Well, somebody at the city of Tulsa can't do anything. People are running lights or doing things. Of course, there is no jurisdiction over an Indian. Similarly, when Ty was talking, we don't have jurisdiction over the military on the Air Force bases and Tinker Air Force Base, Vance Air Force Base, Fort Sill. Those go to military court. So that's another analogy. If it's a civilian that commits an offense on one of those federal enclaves, we can be in federal court. But if it's a military offender, we don't have jurisdiction. And so again, not their race, obviously, it's their status of being in the military that gives authority to the military to prosecute those people. But victimless crimes, traffic violations, very clear. We can prosecute an Indian in federal court. We have a misdemeanor docket in the Western District. We have 2 dockets. We just had court by video today from Lawton on a misdemeanor charge, issued a ticket. And of course, the tribes can prosecute that as well, as somebody commented. There's some special crimes applicable to Indian country, applies to Indians and non-Indians. A lot of people overlook this. Habitual domestic violence, kind of the third strike you're out kind of a situation, that can be prosecuted in federal court. Hunting and fishing violations, you don't have to be, that can apply to an Indian or non-Indian. Failure to register as a sex offender. And then the federal crimes generally applicable to anybody nationwide. A lot of people forget that there are also federal VAWA offenses. The federal VAWA offenses are not based upon victims, Indian victim. It's based upon interstate commerce, or crossing a state line or crossing into or out of Indian country. So we have nationwide jurisdiction both over non-Indians and Indians. Second page, if you have a non-Indian offender, offense against an Indian, again, we have federal jurisdiction for the federal territorial crimes under the General Crimes Act. The tribe now, because of VAWA 2022, has this expanded jurisdiction over all these categories of cases. And of course, the state under Castro-Huerta now can prosecute a non-Indian versus an Indian crime. Non-Indian crime, under the authority of McBratney, the state can prosecute those. There is no federal jurisdiction, but there's now this new tribal jurisdiction under VAWA 2022 when you have a non-Indian versus a non-Indian, if it's an assault of a tribal justice personnel or obstruction of justice. And that's the part of this new jurisdiction. Victimless crimes, only the state. And then again, these special crimes applicable to Indian country and the generally applicable Indian crimes, generally applicable crimes based on interstate commerce or federal interest would apply to anybody. We talked about the Alaska Native Court jurisdiction over the Alaska villages, which is interesting and new. Now there's one little wrinkle here. Because of the way the federal statutes, of course, we can prosecute juveniles federally for certain crimes. Because of Castro-Huerta, we have to show and here's the hashtag mark. When we have a hashtag mark, we can prosecute a juvenile where the state lacks jurisdiction or refuses to assume jurisdiction, or it's a felony crime of violence, and there's a substantial interest. Now, before Castro-Huerta, we used to be able to say when it's a non-Indian versus an Indian crime, excuse me, when it's an Indian versus a non-Indian crime, there are instances where we could not have prosecuted, and that would be this right here with this percentage mark, non-Indian versus Indian crime. We would have argued in federal court the state didn't have jurisdiction, and so we could prosecute them federally. Well, now we can't do that. Why? Because the state now has jurisdiction over a non-Indian versus Indian juvenile offense. So the only way we can prosecute them federally, and this is as a result of Castro-Huerta, is if the state refuses to assume jurisdiction, or it's a crime of violence. There's a lot of crimes that are not crimes of violence. So that's another interesting limitation. Okay, I'm gonna stop the screen share of that at this point in time. Okay, we had a couple questions. Ty had made a comment. Right. I think the position of the state obviously is reflected in the Castro-Huerta opinion. We've attached the entire opinion and the rationale in the Dropbox. Okay. So the final, well, before we get to that, we're going to give away 3 items here. And we have 2 t-shirts and a map. The first t-shirt is going to be one of the OIVA election protection t-shirts. And I'm going to draw out of the official little card here of everybody that signed up. And okay, Antonio Church, when you send in your email, indicate what size shirt you want. And I don't know if we have all the sizes, but we'll try to get close to it. And also an address of where you want us to ship that to. Okay, the next shirt is our McGirt shirt, which is a quote from the opinion. On the far end of the Trail of Tears, there was a promise. Okay, the next drawing is going to be, let's see. Dara Yellowfish Elizondo. Okay, that's your shirt. Okay, when you send us an email where you want us to ship it to and what size shirt you want. Okay, and then the final prize is one of these Indian country. Well, this is a Indian Territory map. Again, send us an email where you want us to ship it to. That's the grand prize today. Okay, let's see. Who is it? Okay, Gillum Parish. Okay, send us an email with your address and we'll ship it to you. All right. So the final word is black owl. Black owl. And that's after Archie Black Owl. And again, what we want you to do is email this information to, we'll share it again. Let's see. Oklahoma Indian Bar Association at yahoo.com, your name, OBA number, and please include your name as it's listed with the Bar Association. We had a different name. Okay, all right. And unless there are any other questions, I think we are now concluded. It's right at 5 o'clock. We, as Stacy said, we try to run a tight ship, and we want to thank everybody for joining us. We'll probably be having additional CLEs in the future. We ask you to consider becoming a member of the Oklahoma Indian Bar Association. It's available through Eventbrite, and especially want to thank our 4 presenters today. They did a fantastic job. We didn't have any technical issues or anything else. So thank you very much, everyone. Have a great weekend, and we look forward to seeing you in the future.